mentioning a notice for extension of interim order.
Not in the notice. I mean, sorry, not in the list.
Not in the list, my lord.
When it is
It is due to expire today.
returnable date?
Well, the returnable date was on the 17th of September. Thereafter, it was extended till the.
Oh, it is expiring.
It was made returnable today. It is not in the list, but well, in the meantime,
The last order term, Bolchi made returnable today.
Lordship.
Well, it was running in the list. This is the last interim order. It was thereafter modified by the division bench. I'll give you, Lordship, the modification order. Also.
I am for the defendant. I am for the defendant in the matter, Lordship.
No, it's not returnable. It was extended till 11th
Yes, but
November.
it was running in the list.
Aje kau tarikh?
11th tarikh.
11th.
Well,
Lordship, I appeal for the defendant.
modified by the division bench.
Huh?
This order was modified by the division bench. Well, this is the modification order. This is the modification order. Well, the parent order is also here. Well, may I also hand up to your Lordship? This is the parent order first pass. Thereafter extended on the 19th of August.
Lordship, they have given the mentioning notice firstly at 10 today in the morning, and secondly, this order has been modified, Lordship.
That's right. I'm not saying order has not been modified. I handed up the modified order also. Interim order as modified needs to be extended.
Lordship, may kindly put it in tomorrow's list as to be mentioned. We will come and represent ourselves. We will not take any prejudicial action in a day, Lordship.
This was the original order.
The original order was
19th August.
Yes.
That was modified by
By
the
the
appellate court.
Yes, sir.
All right. The last order ta jeta dekhalo 11th.
May I just hand it up to you, Lordship?
Very well. It's a to be mentioned kore supplementary list koro at 2 o'clock.
Lordship, may I make?
2 o'clock.
May
The interim order is expiring today. I have to
no,
extend it.
no, Lordship. But,
Placing it. I'm placing it in the supplementary list at 2 p.m.
Very well, Lordship. We'll be there. Very well.
Lordship, may I make a mention for item number 27, 28, 20?
To be mentioned kore supplementary koro dutor shomoy.
Your Lordship will give me leave to appear on virtually on 2 o'clock.
Lordship.
কি নাম্বার ওরা দেবে আর দ্যাট এটা আমি ছাড়বো না বলে যেটা আমার অন্য একটা ম্যাটারে কাজে লাগবে ওই জন্য
But may I kindly to mention a matter, my lord?
আর তুমি ওইটা বের করতে বলো
Lordship.
ওই প্রিন্ট আউট নেবে কেন আপলোড হয়নি
এখন তো অরিজিনাল
ওটা জাজমেন্ট হিসেবে হবে
মেনশনিং অ্যাপলেট এখন কি অ্যাপলেট মেনশন শুধু অরিজিনাল
আচ্ছা জাজমেন্ট হিসেবে হবে তাহলে শুনুন তাহলে আপনার দায়িত্ব আপনি জাজমেন্ট হিসেবে আপলোড করবেন করে আপলোডেড কপিটা আমায় প্রিন্ট আউট নিয়ে আসবেন এসে ওদের
Lordship, may I make a mention? Lordship, may I make a mention for item 27, 28, and 29?
It will be taken up. If it is not called on, then mention.
Lordship, I need an adjournment. I want to seek an adjournment. I am from outside.
Listed matters to be mentioned. Let it be called on. If it is not called on, then mention at the time of rising.
Okay.
My lord, as per your lordship's direction, this matter is being mentioned. This is a commercial suit where
My
subpoena was.
direction.
Yes, my lord. A subpoena was issued by the department for examination of witness. The commission was fixed yesterday for when the
My direction.
when the requisition
So
for
the order, please.
my lord, direction was given to your court officers, my lord, which was communicated to us.
Okay.
The records were required for
Oh,
origin.
yes.
Yes, my lord. My lord, on
So
8th
it's
of
not
September,
my direction. আমার order ছিল কি?
it is oral direction, my lord. That is what it was
What
communicated
was
to
the
us.
direction?
To come and mention the matter before your lordship, for the records, my lord. I think your lord, this order was passed by the earlier court.
I tell you, it was never mentioned before me. It was some order is there.
Yes,
by
my
the
lord. That
coordinate
is,
bench-
I
coordinate bench.
yes.
Then I was informed by somebody, but whatever reason, by somebody that the record should be given, this, that, and all. So I instructed my officer not to give
I bow
record
down to your
on
lordship. That is
day.
what was communicated to
Yes.
us, my lord.
Yes.
My lord, on 8th of September 2025, a direction was given for issuance of subpoena application for
Now
exam.
what is the purpose? Tell me.
My lord.
What do you want?
Today, my lord, it was fixed yesterday and today.
Ah.
My lord, only difficulty is that the subpoena when it was taken out from the department, my lord, we were not consulted about the dates.
Yes.
There is some difficulty with the dates.
Do one thing. Date is mentioned in the subpoena.
Yes, my lord.
So hold the proceeding for the day. Hold your proceeding, the commission for the day. Yesterday could not be
My
held.
lord, difficulty is today, since it was intimated to us on last Friday, all the councils, we have other predicaments fixed. So I was praying because the
Madam,
mandate.
I cannot change the date of commission. I will not. It is for the it is the commissioner's business.
My lord, commissioner is here. He is present here.
No problem. No problem. You have a talk to the commissioner mutually, both the sides. Get a date fixed.
My lord, then I will make one prayer. The mandate of the commissioner is expires on 2nd of December. Your lordship will pass an order extending that.
So it will come 2nd on December.
2nd December, let it be extended for 15 days. My lord.
No issues. So it will come as to be mentioned. আজকে কত তারিখ? হ্যাঁ? কবে এক্সটেন্ড এক্সপায়ার করছে?
2nd of December.
সময় আছে। সোমবার দিন দিয়ে দাও টু বি মেনশন।
Deeply obliged, your lordship.
My lord,
সোমবার ওয়েট
আজকে হবে না।
সোমবার দিন টু বি মেনশন দিয়ে দাও। And you mutually go before the commissioner and accept your dates.
my lord, the thing is, my lord, there were two subpoenas issued. Defendant, I am the commissioner, my lord, in this matter. Defendant number 4 and 5. Defendant number 4 was
PW 4 and 5.
PW4. So 10-11 is fixed for PW4 and 17 and 18 is fixed for PW5. So my lord, that's the difficulty. So if today the matter is urgent, if my lord says that the records are available today, I can hold a sitting today.
I will not go a step ahead, which is now presently within the domain of the commissioner. Commissioner shall hold the sitting. Parties will come. They will pray for adjournment or whatever. It's their arrangement with the commissioner. Why should I go into it? I
Deeply
will
obliged.
simply extend the time. Yes, that I will do.
Grateful.
Monday to be mentioned.
Deeply obliged.
Give the ask your junior to give the slip.
My lord, give
Yes,
the
sir.
order.
My lord, may I permitted to mention a matter regarding the inclusion of this matter. This matter has been directed to be listed on 9th of November 2025, but it has not been listed.
What is the matter?
Matter is commercial suit.
Hearing of a suit.
No, it's a framing of issues.
No, not now. Next.
May I mention, my lord, one matter, my lord, sir, affidavit is a petition by the respondent.
Take the microphone.
Petition by the respondent under section 8 of the Arbitration Act, my lord. The affidavits are ready. This matter was due
It
to
will be
appear.
taken up in due
It was
course.
due to
Now,
appear in the list on 4th of this month, my lord.
very well. Next.
May I permit to mention this is the
Unless interim order is there or expiring of interim order is there,
Ready for hearing, my lord.
let the list be called on.
this is the assigned matter of the appellate side division bench.
Sorry, no, not now. Mention after January.
Interim order expiring tomorrow, my lord. In terms of my lord's previous order, my lord, may the matter be taken up even if it comes as to be mentioned for extension of the interim order.
Tomorrow.
May I have a lordship's kind leave to mention, my lord?
Extension of
Mentioning upon
interim
notice.
order. Tomorrow.
My lord, I'm praying for your leave to file the written statement in the department, my lord.
Why should I give you leave?
My lord, it is appearing in the list at item number 84. It is beyond 30 days, but within 120 days, my lord.
So
Today is
you have
91st
to
day.
take out an application.
Okay, my lord.
What? Who has sent you? What is
Sir,
your name,
this was,
sir?
my lord, this was the procedure being followed by Justice Krishna Rao, my lord.
What is your name, sir?
Lord Harshit Thirani. Harshit Thirani, my lord.
Between 30 and 120, you have to come up with an application.
I'll do that.
Just like that, you will file it, sir.
My lord, Mr. Mukherjee is appearing from my lord.
Yes.
Sorry, wait, was the. I apologize, Your Lordship. This is a written statement to a counterclaim, Your Lordship. There was a liberty was given for me to file the written statement to the counterclaim as per the Commercial Codes Act. I will come up with an application. The procedure before was to mention the matter.
No, but it is today is which day?
It is somewhere within the 91st day, Your Lordship.
So 91st is fair enough. You go and affirm an application and file it.
Yes, Your Lordship. I will
Mention the application tomorrow. I direct it to be listed within
be
2
done
days.
within the
Within 2 days, I will direct
I will.
it. Yes.
Grateful.
Your Lordship, may I be permitted to mention? It is a division bench matter with Honorable Justice Narayan. It has been assigned before Your Lordship.
Mention after January.
Okay, grateful.
Primary determination is this. So I have to try to get do justice on the pending list. Yes.
My lord, I am for the plaintiff.
I appear for the blood. I am the receiver in this matter, my lord. I have been appointed with an order dated 27 October 2025. And my lord, I have been asked, my lord, to paste notice today at 11:30. I have mentioned, my lord, that I have some matters, my lord, where I need to be present, my lord. That is why I have mentioned that, my lord, may this duty be allowed to be done on Saturday, my lord. This Saturday.
Why this has come in the list?
My lord, it has been mentioned at my instance, my lord.
Yes, then what happened?
My lord, as per
Why
the
it was mentioned? Why?
but
What
I had
purpose?
mentioned, my lord, because, my lord, as per order dated October 27, my lord, I was directed, my lord, to visit the premises today at 11:30 to paste a notice, my lord, which was.
You're the receiver.
Yes.
Go and visit.
And
I'm
also
just
collect
asking,
the
my lord,
keys.
instead of today, let it be on Saturday, my lord, because, my lord, I have some fixed matters today, my lord, I have to attend.
Sir, since you are appointed as an officer of the court, unless there is
Today is a court
so
day. That
casually, I will not extend that direction. Or you leave the job. I don't mind. Court has appointed you as receiver, and according to your wish and will,
no, my lord, not wish it.
court
Today is
has directed you to go today.
yes, my lord.
And
Earlier, I had pasted the notices. Which was
whatever, it's the
very-
direction of the court.
Yes, yes.
I will not modify.
I'm just seeking instead of today, my lord, on
No.
this Saturday only, I will.
I am not. It cannot be like that. Unless it is such a ground that you are really unable to attend. Either you go or you leave.
Lord,
You leave the assignment. I'm appointing anybody else.
Lordship, in that case, my lord, I leave it to
Huh?
my lord. In that case, my lord, I leave it to my lord. My lord. Because my lord, today is a court day, my lord, I have to attend.
So
them.
come up with an application. I will not extend. Sorry, I'll not alter. Yes, next.
Very well.
Ashun. এই জন্য তুমি মেনশন এসছে
Yes, my lord, I had mentioned this.
সাহস আছে
But today is, I have to address, my lord, I have to.
No,
It's a division
you
bench
are-
matter, my lord. That is why.
I appreciate your courage. Court has directed you to go there and do the whatever work court has directed. Yes, unless such a situation, such an urgency which really makes you immobile, yes. Otherwise, no. কি দেখি order দেখি. Which order?
27th October 2025.
27th of October.
My lord, in that case, your lordship may kindly just makes it not today, my lord, I'll do it today.
Huh?
In that case, my lord, kindly, my lord, do not pass an order, I'll do it today, my lord.
No, but the matter has come as to be mentioned. I have to pass an order.
Your Lordship, in that case, my Lord, kindly makes it pass over at 2 o'clock, my Lord. I shall come.
What Passover?
At,
I will pass
for
that
the day,
order.
my Lord.
Let me, since you are going, don't worry. Allow me to pass order.
Very well.
It will not affect you.
Very
Today, the matter has appeared under the heading to be mentioned at the instance of the learned receiver appointed in the matter to carry out certain direction, comma, as directed by the coordinate bench on October 27, 2025. First one. Paragraph. Learned receiver, Mr.
Alim. ALIM.
Altamash
What's your
Alim.
full name?
Altamash Alim.
Altamash
Alim. ALIM.
ALIM.
M.
Learned receiver, Mr. Altamash Alim, has informed this court that we shall carry out the direction as per the direction of the coordinate bench. And accordingly, no order is required to be passed.
My Lord, your Lordship will kindly indicate, my Lord, he was supposed to visit at 11:30, my Lord. Now, my Lord.
Yes, 11:30 is time is there.
My Lord, it's at Bidhan Nagar, Ultodanga, my Lord. It will be difficult for everybody to reach.
Very well.
My Lord,
Ask your client and ask whoever to be there
my Lord,
until he goes. Until he goes.
My Lord, I'll.
And don't try to ask your client, don't try to do anything contrary to the.
No, my Lord, not at all, my
Yes.
Lord. This is my
Ask your
suit, my
client.
Lord.
Ask your client.
My Lord, I'll instruct him.
So accordingly, no order is passed. Sure.
Grateful.
Yes.
Appearing for the petitioner, my lord.
Terms of settlement filed.
Lordship, terms of settlement, your Lordship was of the view since the defendant number 2 is a pro forma defendant, he was not a party to the terms of settlement.
It was not party to the terms
of settlement, your Lordship.
So the terms is not valid against defendant number 2.
Lordship, Lordship, I'm carrying judgments as well. I was only humbly praying a decree be passed as against the plaintiff and the defendant number 1, who are parties to the terms of settlement.
Show me. Give notice to the defendant number 2 and I will.
Lordship, the defendant number 2 has not entered appearance. It's a pro forma defendant, no relief prayed against
Very
them,
well. Give
and
one
has
more
not entered appearance.
Show me the terms of settlement.
Your Lordship, the terms of I'll indicate the case in a nutshell. The plaintiff had supplied certain goods to the defendant number 1. The plaintiff is the authorized.
The counsel, you show me the law that if 2 defendants are there, even if pro forma is not required to sign the terms of settlement, or his advocate on record is not required to sign the terms of settlement, when the suit is going to be settled amongst the parties to the suit.
Lordship will kindly, Your Lordship, I'm carrying a coordinate bench judgment wherein, Your Lordship, some of the defendants had entered into a terms of settlement in Dada.
Yes, part settlement valid.
Lordship, I am praying for that only. Part settlement
valid.
Lordship, I'm only praying for that. Part settlement as against the defendant number 1. That is my prayer, Your Lordship.
That's valid.
Lordship, only to that extent.
That's valid.
Here, Your Lordship.
Still, you have to give one notice and come back. Ashok.
Very well, Lordship.
The plaintiff and the first defendant have entered into a terms of settlement on September 23, 2025. comma, the same has been filed before this court today and is taken on record. Full stop. The terms of settlement shows that the authorized representative of the plaintiff and the defendant number one have signed, along with their respective advocate on records in the suit. Paragraph. The defendant number two, though pro forma, neither has signed the terms nor its advocate on record has signed the terms. Post. Paragraph, Mr.
Varun Kothari. Varun Kothari. VARU.
Kothari, learned advocate appearing for the plaintiff, submits that a settlement may be recorded between plaintiff and the first defendant. Paragraph. Now, Okhani. He submits that the second defendant has not entered appearance in the suit, despite service of writ of summons. Full stop. In view of the above, report ke debe summons service hoyeche ki hoyni? Office of the Sheriff. In view of the above, the Office of the Sheriff is directed to file a report whether the writ of summons has been served upon the second defendant, and if so, when? When? Full stop. The plaintiff shall serve a further notice upon the second defendant along with a copy of today's order and a copy of the terms of settlement, and file an affidavit of service when the matter shall be taken up next. Paragraph. The matter shall appear under the heading for settlement on November 27,
Very well, Lordship.
2020.
Your Lordship, I beg to appear for defendant number one in the matter.
Mathar upor likhe do. Who is there? Mr.
Akash Nagar.
Akash Nagar, learned advocate, appears for the defendant number one virtually.
Grateful, Lord.
এটা দিয়ে দাও, এটা দেখে দাও রেকর্ড। এই ফাইলটা তোমাদের কাছে রাখো, ও দিদি দিলে এটা ফাইলড আপ করে আমায় দেবে।
Grateful, Lordship.
হ্যাঁ, নেক্সট।
Item number 3.
This is it says records not here. That's what it says in the list. There's a perjury application, affidavit directions have to be given.
That's right, but since the record is not there.
Lordship, the interim order.
Expiring on 14th is there.
Oh, but there are two J's. One is the main J, where interim order was passed ad interim at then extended affidavit directions, and it is expiring on 14th of this month. That is on Friday. And the second one is the perjury application.
Lordship, may I submit that there is one more application at my BS for acceptance of the written statement, but I'm more concerned with the GA1, which is they're enjoying an interim order, Lordship. This is a banking matter, Lordship. What has happened is due to this interim order.
That's all right.
Yes.
That's all right. But when those applications will appear?
They are all in the list.
So these are all in the list.
All in the list.
So hold the perjury for the time being.
Yes,
proceed with your injunction.
Yes, Lordship.
You can proceed with your injunction application.
Yes. Injunction application is after affidavits. So not as a new motion. New motion, it's come because of purchase.
Mr. Mitro, I tell you, that's the problem I'm facing. Even under the heading to be mentioned, witness action is there. Even under the heading to be mentioned, examination of judgment debtor is there in the list. In so many matters.
You're also supposed to know
I
what.
tell you, have you watched the first 2 days? I have given the instruction the way we have been taught since our childhood in the profession, that Monday motion, new motion, urgent motion.
Tuesday chamber.
Tuesday, Wednesday, Thursday chamber. Then again Friday the other matters. But after 2 days, they were published in the list. I find it is impossible to.
No, but the to be mentioned, to trial hearing, etc. gets.
Yes. They are there. In one such matter, Mr. Dhruvo Ghosh appeared.
Most respectfully, today it was supposed to
Please,
come at as
wait.
a fixed matter.
So I will not be able to manage the list like that. And more so, the problem is in so many matters, suppose interim order is expiring today, and today is Monday. The matter has been made returnable by chamber as chamber application. So that is why then immediately third day onward, I deleted those instructions because the litigant will suffer. The interim order will lapse. Ultimately, the litigant will suffer. So I deleted that instruction as it was appearing. Let whatever returnable on what day, let us take it up. So either you can proceed your injunction application, or you can wait for perjury that till the record comes.
Yes, sir, because
This
the interim
record
order
is
is still. Interim order was passed last year.
December 2020.
In last year, it's been affidavits are complete and the matter has to be heard. In fact, the hearing had started when after that the bench has changed. This will take some time also.
If the interim order is expiring when?
14. It's been extended from time to time. It's expiring on 14.
So I'm keeping it as to be mentioned on 14.
May I most
14th
respectfully pray that as my learned senior has submitted, that it was actually been heard at length, and we have expressed our difficulty because of this interim order. Our original application before the Debts Recovery Tribunal is also stayed because they have also challenged the classification of the NPA itself. Lordship, today this is the last order passed where the learned coordinate bench had recorded our difficulty and fixed it as a fixed matter today at 3:45 p.m.
Again, I don't believe in time. Fixing at a
Lordship,
particular
then
time.
most respectfully, Lordship may kindly take up the hearing, because now after the interim order has been passed, there has been a subsequent judgment by the Honorable Supreme Court,
In my
which
favor.
has clarified that that's subject to
And the Madras High Court also.
consideration.
No, that's all right. That's all right.
That has also clarifies certain things. And Lordship, this the recovery of more than 1 crore of dues has been stalled.
I keep it to be mentioned on the next day for extension. On that day, you make your submission. Let's see what can be done. কি বললাম? আসুন। This is serious. Oh, এটা তো কোনো অর্ডারই নেই। এই কাগজই তো নেই। So passed over for the day. কাগজ নেই. I cannot.
Also, as to be mentioned on that lordship can
It will remain like this. Just passed over for the day.
Tomorrow, then tomorrow.
Here again.
That's right.
Next. Okay.
If all the papers come, then I will take up. Even I can take up your application tomorrow, if necessary. Get ready on the urgent motion also.
As to be mentioned only, we shall.
Not to be mentioned. New motion.
Oh, this is as a new motion.
Just passed over for the day because no paper is there. I cannot pass any order.
I'm okay.
Thank you.
I am for the petitioner, my lord.
Your Lordship, I am for the defendant, Your Lordship. May I have the leave to appear virtually?
No paper লেখা আছে?
Your Lordship, no papers, Your Lordship.
Tomorrow.
My lord.
Grateful.
It will remain in the list.
Item number 5.
I am opposing this application.
Released on my personal account. This matter stands released from my list on personal ground. Good stuff. Paragraph. Records are directed to be sent before the Secretariat to the Honorable the Chief Justice for necessary assignment. ওদের নাম দিয়ে দেবেন, শুধু একজন অ্যাপিয়ার করেছে, মিস্টার নির্মল।
I'm for the defendant. I am for plaintiff, my lord.
Your name?
Hare Ram Singh.
Hare Ram Singh, learned advocate, appears for the plaintiff virtually. Mr. Nirmalla appears for next.
Second number 6. Second number 6. Purana Market Price Private Limited.
May please your lordship.
You're for?
I'm for the plaintiff, but I am for the plaintiff. The plaintiff is the resolution professional, my lord, who is filing the suit on behalf of the plaintiff company, which is undergoing corporate insolvency resolution process. Now, my lord, at the interim stage, my lord, there's an interim order passed in our favor, my lord, and my lord, the interim order is still today. We were directed to serve. We had served them. The envelope has come back with the address, no such company in the address, and we have served by email also.
Affidavit of service?
Affidavit of service is filed, my lord.
So you have to attach the envelope.
But we have attached the photocopy because this is the, my lord, the plaint and the petition going.
Correct, but that's the procedure.
But
you have to attach the whole thing.
Very well, we shall do that, my lord.
That's the procedure.
Because it was such a voluminous thing.
I understand.
We shall do that in course of the day. In course
I appreciate the practical difficulty, but the rule is that.
I shall. In course of the day, we shall. But the interim order is still today.
Till today?
Till today.
Ashun.
But we have also, my lord, attached the email, my lord, which we have. I'm sorry, my lord, I stand corrected. We have attached the, my lord, tracking report, not the photocopy of the envelope.
Achha, tracking report says no undelivered. Then it's all right. Ashun.
May I file it?
Mr. Choyan Gupta, Learned Counsel, appears for the petitioner. Paragraph. Mr. Gupta, please hear me.
Yes.
Mr. Choyan Gupta, Learned Counsel, appears for the petitioner. Full stop. The affidavit of service filed by the plaintiff shows, filed on behalf of the plaintiff shows that efforts were taken to serve due notice upon the defendant. However, the postal track report appended to the affidavit of service shows the remark of the postal department that
no such company in the address.
Quote, bold, quote kore bold. No such company in the address. Bold. In the address. Quote close. It's bold. First up. The interim order passed on September 15, 2025 is expiring.
With my kind indulgence, we have also served them by way of an email that we have annexed with the.
তলা ওর সঙ্গে আরেকটা সেন্টেন্স অ্যাড করে দিন আগে। The plaintiff has also served by official email ID of the at the official email ID of the defendant. Paragraph. The interim order passed on September 15, 2025 is expiring today. That is November 11, 2025. First. You are for? Paragraph. None appears for the defendant, nor any accommodation has been paid for. Paragraph. In view of the above, the interim order passed on September 15, 2025 stands extended till February 16, 17, 2026. No. February 16, 2026. Or until further order, whichever is earlier. Paragraph. Plaintiff shall serve another notice along with copy of the plaintiff petition and a copy of the orders, both dated September 15, 2025 and today's order upon the defendant, and shall file an affidavit of service when the matter shall be taken up next.
If we still find the same thing, then we'll take out an application for substitute service. We'll have to do that.
Sure.
Yes, I'm so good.
আসার দরকার। Now, once again, the matter shall appear under the heading new motion on February 9, 2026. New motion ही আছে তো?
Yes.
Under the heading new motion, under the কবে বললাম? February 9.
I'm so
Thank you. তাহলে আপনি কিন্তু ম্যাডাম এখান থেকে চলে গিয়ে প্রথম ওটা সার্ভার করে প্রিন্ট আউট নিয়ে সার্ভার কপির প্রিন্ট আউট নেবেন। Yes.
My lord, I am appearing on behalf of the plaintiff. I am for the defendant. See, my application is under Chapter 13A, my lord. Under Chapter 13A, my lord.
Chapter 13A or Order 13A?
Oh, sorry, Order 13A, my lord. Chapter, remember the original side.
You are the plaintiff?
Plaintiff, my lord. It is coming after service.
Affidavit has to be filed?
Yes, I'll file an affidavit.
Sure.
I'm entering appearance for defendant number 1, Lord. Only sole defendant. Sole defendant, I'm appearing. Lord.
This is an application taken out by the plaintiff for summary judgment. Paragraph, today is the first day. Paragraph. The defendant oblique respondent shall file affidavit in opposition on or before November 27.
My lord, yesterday, as 20th, 27th, 2nd December, my lord. By 20th?
Can you make it 4 weeks?
November 20.
Yes, Mayor.
2020. No, today we are on 11.
Yes, my lord.
Can you make it 4 weeks?
November 27.
Yes,
2025. Affidavit in reply, if any, shall be filed by December 18, 2025. The matter shall appear under the heading Chamber Application for Final Disposal on January 6, 2025. 2026.
I'm grateful.
Item number 8. David Hampali and another.
My lord, I am appearing for the defendant number 1 in the suit, and this is my application.
I appear for the plaintiff.
This is my application for condonation of delay for filing the written statement. We have received the plaint on 18th of March.
What is the delay? Quantum of delay?
And the written statement was filed on 25th June, which was done. Filed. It has already been filed in the department.
That, my lord, the earlier coordinate bench, my lord, honorable bench had directed that it may be filed upon their mentioning, but
So without application being filed?
My lord, application was filed eventually because the client was from outside. There was a we took leave of Honorable Justice Krishna Rao, and
When the application was filed?
application was filed on 2nd of July, which was the 106th day.
And when the written statement
Written
was?
statement was filed on 25th June on the 99th day.
Written statement, when written statement was filed, the application was not on the board.
My lord, there was a difficulty. What difficulty we faced was the application, initially filed an application which was rejected. There was some. So I had to get it because the client is outstation. I had to get it affirmed from Delhi and get it and refiled it.
So when the written statement was directed to be filed, the application has not even borne.
No, my lord. It was done simultaneously, but that was not there. We took leave from.
Not simultaneously, madam.
But eventually, what? 99 day and 105th day was the application was filed.
I am not on that.
I understand, my lord, the difficulty.
I still believe you have a right praying for extension till 19th day. I have held that in my judgment day before yesterday.
Yes, my lord.
But that I do not know. Show me your explanations.
My lord, this was at paragraph 5 of my application, which is GF4, page 4.
When the plaint was filed?
Plaint was served upon me on 18th March. This was in 2024. Plaint was filed.
When the writ of summons was served?
18th March, my lord. 18th March 2025.
18 March
2025.
You have affirmed the written statement on
25th June it was filed. Written statement is filed.
when the order was passed.
My lord, I will just tell my lord when was the written statement.
Show me the original written statement. Koda. When the order was passed, show me the order that you were allowed to file written statement.
My lord, there was it was noted behind the original written statement, which is
has to be, but no formal order is there.
No, my lord. It was by the court officer.
Possibly it was.
No application, no formal order.
Possibly it was done on mentioning.
We mentioned it, and
it is always done on the fiat. On the fiat, the investment is done very well. আগে রেকর্ড আনো তারপর দেখবো।
My lord, I have some difficulty. My father is in the hospital. I am here only for this matter. If it can be kept tomorrow.
Yes, that I don't mind. But I have to direct. Even sometime after also I don't mind, because whatever will happen
would be
will
really
happen.
grateful
This
if it can be
tendency
next
will
Monday.
not change the
Tomorrow,
status.
Lord, I may have a little difficulty with my father. I have to take him to a doctor, my lord. Tomorrow.
Monday, if it's possible.
All right.
I would be really grateful.
আসুন একটু লেখো, সাবমিশনটা রেকর্ড করে রাখি। Mr. Full name?
Mohit Gupta. Mohit Gupta.
Mohit Gupta, led by Mr. Suman Dotto, Lanet, Senior Advocate, appears for the plaintiff. MS
Oritra Chakraborty.
Oritra Chakraborty, learned advocate, appears for the defendant. Sole defendant?
No, my lord, defendant number one.
And
Applicant
what about the other defendants? You have any idea?
One,
You have filed your written statement within time. Very well. Defendant number one, Mr. Shatik Raut. Spell out. Shatik Raut, learned advocate, appears for defendant number 2, who has already filed its written statement within time. Paragraph. This is an application taken out on behalf of defendant number 2. Defendant number 1. Praying for extension of time to file written statement beyond 30 days, but within 120 days.
Yes,
120th day from the service of writ of summons. Paragraph. Learned advocate MS
Oritra Chakraborty.
Oritra Chakraborty, appearing for the defendant number 1, submits that the writ of summons was served on defendant number 1 on
18th March.
March 18, 2025. Madam, please listen to me.
Yes, my lord.
Upon expiry of the 30 days mandate under Order Roman 8 Rule 1 of CPC as amended, the matter was mentioned before the coordinate bench on behalf of defendant number 1 on.
My lord, I don't have the. My lord, this was on 23rd of May, I believe.
On or about 23rd
of May.
May 23, 2025. When leave was granted by the coordinate bench.
Yes, my lord.
To file the written statement subject to the outcome of the application. The application, the instant application has been taken out subsequently on.
Affirmed on, or my lord, it was filed on 2nd of July. And
July 2, 2025.
Yes, my lord. But affirmed on 20th June.
Have you served the written statement?
Yes, my lord.
Huh?
Yes, my lord.
I think they have.
It is submitted that the written statement has already been the written statement affirmed on
22nd May.
May 22,
yes,
2025.
Yes, my lord.
Has already been served upon the plaintiff. Full stop. In view of the above, the department is directed to produce all the suit record before this court on the next, when the matter shall be taken up next. So that the actual date of filing of the written statement can be ascertained. Full stop. The matter shall appear under the heading New Chamber application on November 18.
My lord.
18th November.
Yes, my lord. Obliged.
Yes, Mr. Dutt.
My lord, 31 and 32 are also connected application in this.
Madam, let me reach.
My lord, I might not be there. My junior will be there.
No harm will be done. This much I can assure.
Obliged. always wait for.
কবে রাখলাম? 18 তারিখ।
Case number 9. Paid with voltage activities.
May it please, my lord. I appear for the defendant. This is my application, my lord. Seeking extension of time, my lord, to file my written
Take the
statement.
microphone.
I am for the plaintiff. My lord, written statement filed within 120 days, my lord, but
This
beyond.
is the connected matter, the other one which I have allowed.
My lord, not
For some of the defendants I have allowed.
No, my lord, this is another
It's
matter.
a new.
Another.
Yes. Show me.
My lord, I have received the writ of summons on 29th of May 2025, my lord, and I have filed the written statement, my lord, on 1st of September after taking leave from the honorable court, my lord.
And when you have taken out the application?
Application was taken out, my lord, on 29th of August 2025.
So you have filed the written statement when the application is pending.
When the application was filed, my lord, before it was filed, but written statement was filed subsequently upon taking leave. It was always subject to the outcome of the application. That's how the leave was given earlier.
এই ওই কালকে একটা সার্ভার করেছি অর্ডার, কাকে দিয়েছিলাম? এক্সটেনশন অফ রিটেন স্টেটমেন্ট কালকের। আরে কেউ তো নিয়েছো তোমরা কালকে। ওই লিস্ট নেই? হ্যাঁ, আচ্ছা ঠিক আছে, নিক না, আমার তো সার্ভার থেকে বের করা নিয়ে কথা। বের করো। সার্ভার থেকে বের করা নিয়ে কথা, যে খুশি নি। Yes, show me the explanation.
Yes, my lord. It starts from paragraph 2 of my application, my lord. And my lord, it goes on till paragraph.
No, read on, read on.
Yes, my lord. The petitioner states and submits that the writ of summons was served upon him on 29th of May 2025, and thereafter he started with the process of finding his bank statements for the year 2006, which were not readily available with the defendant to contend with the allegations of the plaintiff. The defendant was further advised to collect the annual returns and financial statements filed by the plaintiff company with the ROC, and accordingly the defendant approached his friend to help him to get the said documents from the ROC. The said documents were received by the defendant on 19th of August, and thereafter the defendant contacted his learned advocate on August 21 for preparation of the written statement. Thereafter, a few rounds of sittings were held with the learned advocate. Thereafter, the written statement was finally prepared, and the affidavit of the written statement was affirmed on 29th of August 2025.
পেয়েছো? আমার একবার দেখো। আস্তে 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 একটু নামো। হ্যাঁ চলো, ওঠো 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 ওঠো, 1 মিনিট। ওঠো 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 ওঠো। You have a copy? No, that's the not the thicker one. That's yesterday one. এটা কি ওদেরটা? এটা এত বড় তো কালকেরটা ছিল না। কালকে একটা ছোট্ট দিয়েছি। अच्छा उठो 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 হ্যাঁ ঠিক আছে এটাই দাও এটাই দাও এটাই দাও আর কি করবো এটাই দাও প্রিন্ট আউট দাও কি কস্ট ঠিক আছে কস্ট তো হবেই Yes, what do you say, sir? You are delayed by 60 days.
Yes. Exactly 60 days.
Issue. Mr. Ashish Kumar Mukherjee, London advocate, appears for the plaintiff. Mr.
Altamash Alim.
Altamas Alim, London advocate, appears for the defendant. Number?
Only sole defendant.
Defendant. Full stop. The master summons has been taken out by the defendant, inter alia praying for extension of time to file written statements in a commercial suit beyond 30 days, but within 120 days from the service of writ of summons. Paragraph. The averments made in the application in support of master summons, the averments made in the affidavit in support of master summons shows that there has been a delay of there has been a delay for about 60 days, beyond 30 days. Full stop. The writ of summons was received by the defendant on
29th of May 2025.
May 29, 2025.
Yes.
এই ডেটগুলো বোল্ড এই ডেটটা বোল্ড হবে আর ওই ডিলেড ডেটটা বোল্ড হবে 60 ডেজ ঠিক আছে upon the matter, please listen.
Yes, ma'am.
Upon the matter being mentioned by the defendant, leave was granted by the coordinate bench on
Lord, on or about Lord August 29, 2025.
On or about, no, on.
Lord, exact date, Lord.
Then you have to wait till the record comes. You got mentioned, you got the leave, you don't know. There is no record.
Lord, it is 29th of August. It is 29th of August at the back.
On
August 29, 2025.
August 29,
2025.
2025, comma, as the learned counsel for the defendant submits before this court. Full stop. The master summons has been taken out on
August 29, 2025.
On the same day?
On the same date.
On the same day, August 29, 2025. Full stop. Subject to the fate of subject to the outcome of the instant application, the written statement was directed to be filed.
Yes.
Paragraph. The principal plea, paragraph, of the defendant in support of its prayer for condonation of delay is quoted below. From the supporting affidavit is quoted below. Para 2, quote 1. Para 2 and 3. Para 2, 2, 3, 4. 2, 3, 4. ঠিক আছে? Page 2. Quote 1. খুলে দাও। ওদের দাও, ওদের দাও। লেখো কোট 1। না না দরকার নেই, আমারটা খুলে দাও না, না হলে দাও আমি খুলে নিচ্ছি। তোমার পকেটে রাখো, দরকার হবে, তোমারই দরকার হবে। কোট 1, হ্যাঁ? After considering the submissions made on behalf of the parties and on perusal of the averments made in the supporting affidavit, comma, it appears to this court that it prima facie appears to this court that sufficient ground has been made out for condonation of delay as prayed for in the master summons. না এটা আগে লিখো না, এটা কেটে দাও, কাটা। After considering the submissions made on behalf of the parties and on perusal of the materials on record, it appears to this court that বলে ডট ডট করে না, এই প্যারা 6, 7, 8
আপনি আমাকে দিয়ে দেবেন, আমি এটা দিয়ে দিব।
9
আপনি নিয়ে নিন এটা।
9 ঠিক আছে। From এটা লিখে নাও, এটা আমায় দিয়ে দাও, লিখে নাও, কপি পেস্ট করে দেবে একদম। সিক্স থেকে 9 বলেছি, ঠিক আছে, লেখো। Since the written statement is already on record, comma, pursuant to the direction of the coordinate bench as recorded above, the same shall be regularized and scrutinized in accordance with law and shall be taken into record and shall be treated as a part of the suit record, subject to payment of cost of rupees 50,000 to be paid by the defendant in favor of the State Legal Aid Services Authority, comma, West Bengal, within 3 working days from date. ঠিক ওখানে যেভাবে যেটা বোল্ড বোল্ড করা আছে সেটা সেইভাবে বোল্ড বোল্ড করে দেবে, ঠিক আছে? 10 নম্বর প্যারাগ্রাফে দেখে নেবে। ফুল স্টপ। After production of the paragraph, the plaintiff shall produce a copy of the money receipt to the learned advocate on record, money receipt showing payment of cost to the learned advocate on record for the plaintiff forthwith. Forthwith now, plaintiff, full stop. The learned advocate on record for the plaintiff shall also produce a copy of the money receipt before the department concerned immediately after payment of cost, and only thereafter the department shall regularize the procedure and make the written statement as part of the suit record. Written statement served.
Yes, sir.
Paragraph. The written statement, this court has been informed that the written statement already filed has been served upon the already filed has also been served upon the plaintiff. Paragraph. With the above observations and directions, এই এটা একটু মার্ক করে রাখো তো কত নম্বর করলাম, এর পরের বার থেকে এই অর্ডারটাকে কপি পেস্ট করব। কত এটা? 9। তুমি এটা একটা আমার কপি দিয়ে আমাদের এখান থেকে নিয়ে আমরা কপি পেস্ট করে দেবো। ঠিক আছে, এটা ওই আমার আর্চ ফাইলে গুজে দাও, এটা আর্চ ফাইলে দাও।
May I pray for one?
With the above observations and directions, this application IA number GACOM
1 GA1
of 2025 stands allowed. Without stands allowed, comma, full stop. Chalo, next.
Lord, just one observation. Your Lordship may kindly reduce the costs. Costs have been made.
Very well. 1 lakh.
But I'm praying for
Next.
grateful.
Item number 10, Central Bank of India dollar.
May it please your Lordship, Milord. I'm appearing on behalf of the defendants numbers 16 to 18. This is an application, Milord, asking for extension of time to file the written statement. I'm led by Mr. Ghosh, Milord.
Milord, much better condition than the order that your Lordship has passed in favor of the first set of defendants, 5 to 15.
Give me that judgment. Yes.
Milord, few dates.
Give me the list of dates.
Yes, Milord. I have the dates. Only 2
Come on
dates.
the next day.
But only 2 dates are there.
Passed over for the day.
Item number 11.
My lord, this is for the same in the same suit for defendant numbers 21 to 25.
Mr. Rupak was appeared in that matter.
The
Same suit.
Same suit.
Give me the
my
list of dates.
lord. My lord, I am also seeing the
Next.
Item number 12.
On 12, I appear for the decree holder. Now, my lord, in this matter, I have obtained a portion of the decree, my lord, which was deposited by the defendant during the trial. During the trial, my lord, this is a suit for recovery of money for goods sold and delivered. My lord, decree in my favor on 31st of January 2025. Thereafter, my lord, I put the decree into execution. The money which was deposited by the defendant during the trial was paid to me. Now, my lord, the balance portion of interest is outstanding. My lord, we have served upon the defendant, the judgment debtor, the decree as well as the execution, my lord, notice by email, because it's a company which has a registered email.
Decree dated
31st of January 2025.
within 2 years.
Yes, my lord. Now, my lord, the email has been delivered to the
Execution application filed, then an interlocutory application. This is an
No,
interlocutory.
no, my lord. This is not an interlocutory in the
Main
This is the
execution.
main execution.
Correct.
My lord, in the main execution, because there was a deposit already with the honorable my lord, learned registrar, I got that money from the registrar. During the trial, the defendant was directed to deposit, secure the money, which was admitted by the defendant.
No, no, how you could get it back?
My lord, my lord, your lordships have passed an order directing, my lord, not your, my lord, the coordinate bench, my lord,
Acha.
the predecessor bench, my lord, directed the money to be released to the decree holder. I have obtained that money. Now, my lord, the interest amount which was granted to me under the decree is outstanding. I have served upon the judgment letter through email the my lord, the notice for the execution case as well as the orders that have been passed. There is another order passed, my lord, in the earlier occasion directing attachment of their bank account. My lord, the judgment letter has refused to appear.
Bank accounts are attached.
My lord, direction was there for attachment, but my lord, the difficulty is that the
Have you
amount.
served upon the bank?
My lord, but the difficulty is that in the order, it records the principal amount which was decreed for attachment. But the principal amount I have obtained. It is only the interest which is
So
outside.
that order has got no meaning now.
Yes, my lord, that's the difficulty.
So interest how much?
My lord, it's about, at the moment, about 11 lakh rupees.
Where is the particulars of bank account? Show me from the tabular statement.
My lord, if your lordships has the tabular statement on the second page.
এটা the কি আছে 1 minute.
सितंबर का शूटिंग करने की रिपोर्ट होगा जब माइंड रिपोर्ट फ्रॉम डिपार्टमेंट
ना अटैचमेंट का
इसके बाद
अटैचमेंट है कितनी प्रॉपर्टी का अटैचमेंट 2 and 3 2A हम लोग कितनी देख सकते हैं चलिए रजिस्ट्री इंश्योरेंस रजिस्टर ऑफ एश्योरेंस को नहीं कर सकते हैं
Ashu, just one second. Mr.
Kanishk Kejriwal.
Anish.
Kanishk.
Kanishk.
Yes.
Kanishk Kejriwal, learned advocate, appears for the plaintiff
decree
holder. Paragraph. None appears for the defendant stroke judgment debtor. Plaintiff stroke decree holder, defendant stroke judgment debtor. The last order, paragraph, last order dated September 15, 2025 shows that the decree holder was directed to take appropriate steps for issuance of notice of the execution proceeding, instant execution proceeding, upon the judgment debtor through the learned district judge, Alipur, within a week from that date. And the matter was made returnable today. The report of the paragraph, the report of the Office of the Sheriff dated November 4, 2025 shows despite the original copy of the notice, the original note, despite notice was sent to the office of the learned district judge, Alipur, on October 27, 2025, by special messenger of the office of the bailiff. The same was not received by the office of the learned district judge. Accordingly, the original notice was returned, and the same has been made part of the report of the office of the sheriff. First up, the report along with the appended notice is taken on record. First up. Accordingly, both the plaintiff and the office of the sheriff are directed to serve a copy of the last letter dated September 15, 2025, along
Order dated, my lord.
Order dated September 15, 2025, along with a copy of the entire set of execution application and a copy of today's order at the office of the learned district judge, Alipur. Forthwith. The plaintiff decree holder shall file an affidavit of service, and the office of the sheriff shall file a report in this regard before this court when the matter shall be taken up next. Paragraph. Show me. Paragraph. Show me. 1 second. Learned counsel for the applicant decree holder, referring to the tabular statement attached with the execution application, submits that the principal amount of decree for a sum of rupees 17,24,400 has already been received.
We have received a little more than that. 17,65,000 has been received. Because my lord, the deposit was slightly higher than the principal amount here. Seven, 17 lakh.
49.
Sorry.
Check. We have received 1749.
That is sum of rupees 17 lakh
49,575. 49,575.
17, 49,575. 17,49,575. It a bold korbe rupees has already been received by the plaintiff decree holder. The decree holder, full stop. The decree holder now proceeds for realization of the amount of interest under the decree after adjustment of the excess amount already received over and above the principal. Decreed principal amount. Where are the bank accounts?
Column 10, overleaf. Overleaf of the tabular statement.
Yes, column 10.
Item Roman 2. Attachment be made of the following bank accounts in the name of the respondent judgment debtor.
Full stop, paragraph. Column 2, column 10. Bold, huh? Column 10 of the tabular statements under serial number Roman 2. shows the details and particulars of the bank accounts of the defendant judgment debtor. Paragraph. Since the decretal amount has been crystallized, and the defendant judgment debtor is not represented, comma, this court prima facie is of the view that the decree needs to be protected and should not allowed to be made a paper decree. After the claim, since the claim of the plaintiff has already been adjudicated upon, and the defendant is liable to pay the decretal sum. Paragraph. In view of the above, there shall be an order of injunction restraining the defendant, defendant oblique judgment debtor to operate any of the bank accounts in any manner whatsoever. Any of the bank accounts as mentioned in column 10 to the tabular statement in any manner whatsoever until further direction of this court. Full stop. Paragraph. The plaintiff shall serve a copy of the execution application along with a copy of today's order upon the concerned branches of the respective banks forthwith to enable the banks to take steps as per the direction of this court. Lady. What's your name?
Priya Ghosh Dastidar.
Full stop. Considering the facts and situation, further, this court is of the firm view that so long the decree is not satisfied, a receiver is also required to be appointed over and above to make an inventory of the properties, immovable properties, two immovable properties mentioned under item Roman 3, item থেকে Roman 3 to the tabula to the under column 10 to the tabular statement. কি বললাম? When you are enrolled, madam?
2021, Your Lordship.
Sufficiently senior. Chalo, ठीक है? Full stop. Accordingly, MS
Shreya Ghosh Dastidar.
Shreya
Dastidar.
Ghosh Dostitar. Give your phone number. Learned advocate, bracket phone number ta diye deben, is appointed as receiver who shall visit the said two immovable properties on the date and time to be fixed. Please listen. On the date and time to be fixed by her, as per her discretion. Upon notice to the learned advocate on record for the plaintiff, decree holder. Paragraph. The initial remuneration shall be paid by the plaintiff for a sum of rupees 25,000 to the learned receiver. Full stop. The plaintiff shall arrange the conveyance for taking the learned receiver for holding the inventory of the said two immovable properties. And then shall return the learned receiver to her place. Full stop. The learned receiver so appointed, paragraph, shall make an inventory of the said two properties upon notice to the defendant. Upon a prior notice of 7 days to the defendant. 7 days. Now, upon a prior notice of 4 days to the defendant. Paragraph. The defendant, single.
Yes, my lord, single.
Shall allow the learned receiver to carry out the inventory of the property for the time being. You shall go, madam, you shall go, you shall see that these are the two properties. And if the defendant comes, then you shall record that whose property is this, that's all. Do not enter into the property. Do not enter into the property. The defendant shall cooperate in every respect the learned receiver to comply with the direction of this court. First paragraph. In the event any resistance is there in carrying out the direction of this court by the learned receiver, the learned receiver shall be entitled to take the assistance of the local police station forthwith. And in that event, the local police station, through its officer in charge, / inspector in charge, shall provide all assistance to the learned receiver. Poster. A copy of this order shall also be served upon the local police station by the advocate on record for the plaintiff. Full stop. The matter is made returnable and shall appear under the heading কিসে আছে? New chamber application on. আজকে কত?
11th of November.
Tell me when.
After 3 weeks, Your Lordship.
4 weeks is perhaps.
No. Today 11. 2 weeks. 25th. Right?
Yes, Your Lordship.
November 25, 2025 under the heading chamber application. Paragraph. এর আগে একটা paragraph ঢোকাও. It is also made clear that pendency of this application shall not preclude the judgment debtor to make the payment of the decretal interest amount after adjusting the excess amount paid on account of principal to the plaintiff.
Only one thing, my lord. Your lordships have directed the learned special officer to notify the defendant. Now, my lord, because the defendant's physical address has not been located, may she be permitted to inform by email? Because, my lord, it's a registered company.
Sir, notify means email, address, everything.
Very grateful.
And after amendment of the Evidence Act.
Yes, yes, grateful, grateful.
সবকটা দিদিমণি দিয়ে দিয়েছে?
Thirteen, my lord.
I appear for the decree holder,
We are led by Mr.
Mithran.
Behind your back a lovely aquarium or what?
It is a board, the display board, madam. Display board.
You are appearing from where?
Inclat.
Inclat.
Appellate tribunal.
Rajarat.
No, it's in
NCLT and
Oh, NCLT Inclat.
it's Inclat. I'm sorry, madam. This is an execution application.
Regular fee coupled
No.
Station 1.
Now station 1. Obviously, my lord. My lord, we will learn from my lords all this.
Yes.
My lord, it's an execution application.
Plaintiff.
Yes, the petitioner. The petitioner in the execution
All
application.
right, 1 second. You?
But I am for the decree holder, my lord.
Led by
Yes,
Mr. Mitro.
we're all appearing for both the defendants, both the judgment debtors, your lordship. In this matter, there is a moratorium which is subsisting on both the judgment debtors, my lord. An interim moratorium under section 96 of the Insolvency and Bankruptcy Code, my lord, on defendant number 1, and a final moratorium under section 101.
IBC.
My lord, both one in the Mumbai bench, the interim one, my lord, and on the second, I have both these orders, my lord.
No, nothing has been served. Rather, we have served upon them pursuant to the order
And
of this
which is
court.
why I have come before your lordship upon service. I'm coming upon service.
Service, every service directly.
How you have gone under moratorium?
My lord, this is, I'll show both these orders, my lord. If your lordship deems it fit, I will bring it on affidavit on the.
Yes, I will. But how?
My lord, on individual insolvency, my lord, under section 95, on an individual, when
principle is the same.
It's the same. And when when the petition is filed and the case starts, an interim moratorium is imposed, my lord, under section 96. And when the claim is admitted, my lord, under section 101, a moratorium is imposed.
So what is your status? The claim is admitted.
For defendant number 2, my lord, the claim is admitted and section 101 is applicable. And for defendant number 1, the judgment debtor number 1, interim moratorium is applicable, your lordship, and the matter is still pending before the relevant NCLT, before the Mumbai bench for the interim moratorium, and for the final one before Ahmedabad bench.
Show me your tabular statement.
My lord, lordship will find the tabular statement, my lord, at the place where it should be, my lord. At the place, my lord. But the decree of
So automatic injunction is also there.
Your lordship.
Has to be.
That is my prayer.
Has to be.
Your lordship.
Moratorium cannot be a pot-free situation. Show me the properties and bank.
My lord. My lord, kindly come to Schedule A at page 12, my lord. And my lord, details of the bank, my lord, we couldn't fetch, my lord, but with the now everything is linked, my lord. Mr. Mitra is there.
With the PAN number. The only thing I must indicate, my lord, this decree is passed by a Dubai court in Dubai. And Dubai.
Dubai court and
Courts in Dubai. There are a reciprocating treaty between India and Dubai. So it's 87 crores is the principal amount. Now they have some properties within the jurisdiction.
You tell me what Learned Counsel for the judgment debtor is submitted.
I know, I heard. Let them file an affidavit to that extent. I cannot. Yes.
Right, but what are the in the meantime?
Schedule A properties. Schedule A, page 12.
My lord, since the proceedings shall be stayed under section 96 and section 101, an injunction, my lord, cannot be allowed on the property of the judgment debtors, my lord.
Show me the law.
My lord.
Which section?
96, my lord. This is for defendant number 1, my lord. 96.
So then you have to undertake. You give an undertaking. I record your submission. Show me section 96. Show me.
The insolvency and bank.
Speaking.
My lord.
No, somebody else is speaking.
Mute for a
Yeah, your lordship.
For a specific period, interim moratorium.
Which section under which the application has been filed by the creditors? For you, 94 or 95?
95, my lord.
Application by creditor?
By creditor, my lord.
Against individuals?
Individuals.
Then 96.
Your lordship.
Principle the same.
May I, my lord? When an application is filed under section 94 or 95, an interim moratorium shall commence on the date of the application in relation to all the debts and shall cease to have effect on the date of admission of such application. So until the admission is not done, the interim moratorium shall be in effect. My lord, subsection 96(1)(b). During the interim moratorium period, subsection 1, any legal action or proceeding pending in respect of any debt shall be deemed to have been stayed, my lord.
Shall be deemed.
And number 2, my lord, the creditors of the debtor shall not initiate any legal action or proceedings in respect of any debt.
Not a direct stay. Will be deemed. Will be deeming provision. Yes. No, yes, but it will be ensured when gives the undertaking. Yes. There is no harm.
আমাদের দুটো কপি দাও না
আমি দিয়ে দিচ্ছি আমার এখানে আছে আমি মাইলট দিচ্ছি
তুমি তাও জাস্ট দেখে দিয়ে দেবে এই ভাস্কর এই নাও একটা দিয়ে দাও ওনাকে বলার চান্স পাবে তো
Kindly see the date of the order. Way back in 2023, moratorium cannot be for the.
My lord, the section says the moratorium shall be in effect
time
till
period.
the date of admission.
No.
And if
What
your
is the
lordship,
present status?
it is still
Right.
pending. It is. I've checked it online. It is still pending. And my lord will kindly take this order on the third.
Very well, you shall not deal with any of the properties without leave of this court
Your lordship.
for the time being.
Let him file an affidavit to this effect also. One affidavit to this effect. Yes.
Affirm করে দিয়েছি নোটারি হয়ে গেছে only my lord attestation by this honorable court is required within
ঠিক আছে
my lord I'll file my affidavit.
Ashur. This is an application. Acha. First, Mr. Aniruddha Mitra, learned senior advocate, appears virtually with Mr. Dipnath Rai Chaudhary, learned advocate, appears physically for the plaintiff decree holder. Full stop. Mr.
Yashvardhan Diora, your lordship.
Yashvardhan
Diora, Deora, your lordship.
দেখে নেবেন. Learned advocate appears for the defendant oblique. No question of defendant. Decrees of it's an directed.
Yes, date execution.
Appears for the how many?
Both, your lordship.
Judgment data.
Judgment datos. Paragraph. The instant execution proceeding arises from a foreign decree. Full stop. The tabular paragraph, the tabular statements appended to the affidavit application shows the total amount of money decree inclusive of principal and interest comes to about rupees
146 crore
1,46,92, 15,494.
Yes, madam. হ্যাঁ 146 crore ঠিক আছে.
Nothing has been paid. Paragraph. Learned counsel appearing for the judgment debtors has referred to an order dated February 6, 2023, copy of which is taken on record.
My lord, that is for judgment debtors number 1 and this is for judgment number 2, debtor number 2.
For the judge, in respect of the judgment debtor number 1 and the order dated
my lord,
December 14, 2023, which is also taken on record for the judgment debtor number 2, in respect of the judgment debtor number 2, passed by the jurisdictional NCLT. On the basis of the said two orders, learned counsel submits that in view of the proceeding initiated by the creditors against the judgment debtors under section 95 of the Insolvency and Bankruptcy Code 2016. বানান জানো তো? নাও দেখে নাও বাবা। ঠিক আছে? ব্র্যাকেটে for short IBC. The judgment debtors are enjoying moratorium and or interim moratorium in terms of section 96 of IBC.
Interim moratorium under 96, Your Lordship, and moratorium under section 101, Your Lordship.
Interim moratorium under section 96 and 101 of IBC respectively. Full stop. He submits that this proceeding shall not lie. Paragraph. The question, the issue raised by on behalf of the judgment debtors is required to be decided on affidavits. However, now, come on, show me the particulars of immovable property.
My lord. Page 12, Lordship, as I have indicated, my lord.
Column 10, column 10.
Oh, column 10.
Where is Schedule A?
Page 12, my lord.
Page 12.
Yes.
Column 10 the prayer.
Full stop. No. Column 10, the bold habe. To the tabular statement discloses an immovable property, the immovable properties of the judgment debtors, which are detailed in Schedule capital A at page 12 to the supporting affidavit. Since the admitted fact is that paragraph, the defendants, the judgment debtors have suffered a decree, money decree, arising out of a commercial transaction.
Yes, yes.
It's a commercial transaction.
Yes, my lord.
Arising out of a commercial transaction.
That issue has been adjudicated and finalized also.
The decretal amount is also required to be protected to the extent it is possible. But as submitted on behalf of the judgment debtors, in view of operation of section 96 and 101 of IBC, no absolute injunction can be granted at this stage. Full stop. Paragraph. Accordingly, the judgment debtors shall not deal with any of the immovable properties mentioned in Schedule A to the execution application without leave of this court.
My lord, may I submit one humble submission, Your Lordship? At present position, my lord, I am no one in respect of these properties. My properties are handed over to the resolution professional and the interim resolution professional. So in any manner, section 101.
Okay, Guri do. Ki bollam? Now, accordingly, be it by the judgment debtors, be it by the appointed resolution professional under IBC, if any attempt is made or requirement arises to deal with any of the immovable properties mentioned in Schedule capital A to the execution application.
My lord, he's not a party, my lord.
The same should be informed the same has to be done upon prior information to this court and with the leave of it.
As per the subsistence of the IBC with the leave of Mr. Mitra, I say, but how does today he appear? The RP should appear. When the moratorium is going on, the
Very correct. my lord,
IRP is
but
made.
I
How
am-
can he? What is
My
his
lord, the
purpose?
RP is not a party to the present proceeding.
As request,
can't be. Operation of law. ठीक है ठीक है ठीक है
Intention obviously to assist the court, but the
ठीक है Mr. Raichudri, leave it
I'm just informing the
since the judge
As rightly pointed
appointed
out,
resolution professionals, since the judgment debtors are under insolvency proceeding under IBC, comma, তারপর কি বলেছি পড়ো। No. Under IBC, since, comma, this since the judgment debtors are judgment debtors have undergone under the process of insolvency under IBC, comma, পড়ো। That's all.
one.
He should file a vokalatnama. I don't know, Mr. Deoda is holding what vokalatnama here?
I am holding it, my lord. I shall file it within course of the day. I have
Cannot file on behalf of the filed by the RP. It has to be.
Yes. সেইটাই
The appropriate authority shall file. The appropriate person, oblique authority, shall file affidavit in opposition.
उनको बोला है कि आप नोटिस से सीख होती है सारे कागज
Opposition on or before December 10, 2025. Affidavit in reply, if any, thereto shall be filed by January 12,
My lord, a shorter
2026.
date may be given since
Full
there is
stop.
a stay.
The matter shall appear under the heading Chamber Application for Final Disposal on January 15. Oh, no, January 15 হবে না। January 29, 2026.
Lord, I humbly request, my lord, I humbly beg before this honorable court, since there is a stay, I need only 7 days, my lord.
There is no stay, sir.
And my lord, in the meantime, may he be directed to disclose affidavit of assets also, my lord?
Let him come with the affidavit.
No, only thing, liberty be given to me to communicate this order to the RP.
Yes.
Because RP, I don't know who is appearing for whom. To communicate this order, yes.
Put on record for the decree holder shall communicate this order to the appointed resolution professionals.
Obliged.
Resolution professionals.
Obliged, deeply obliged, deeply obliged, deeply obliged.
এই বাহাদুরকে ডাকো, বাহাদুরকে চলো। I'm coming. কত আজকে এটা কত হলো?
13.
হ্যাঁ, I'm coming. I'll take up action motion.
Item number 14.
My lord, I appear for the plaintiff.
I'm for the defendant.
Today one application is appearing in my lord's list. That is the plaintiff's application for summary decree under order 13A of the Code of Civil Procedure as applicable to the commercial. Well, pleadings are complete. Now there is a defendant's application as well, which is GA2, which is a demurrer application. But it's not appearing. But my lord, may I humbly submit, possibly that application has lost its force because that was filed on the ground.
No, but unless it appears,
No, may I just indicate one?
May I indicate? My application under Order 7 Rule 11, my application under Order 7 Rule 11 was GA number 2. That was hard, and hearing was completed and was reserved for judgment. Thereafter, on
reserved for judgment. Show me the order.
Yes, but then kindly, then a judgment was delivered by which only regarding one of the issues that I raised, the matter was sent to the larger bench. The entire
sent to
the larger bench. This is that 106 whether commercial.
106 commercial suit, whether permissible or not. That only on that issue the matter was sent to the larger bench. Entire file and my application, both the suit file and the application, both were sent to the larger bench. Larger bench has now decided the issue, saying yes, the suit is maintainable on that aspect. It can be a commercial suit even if the termination is under 106. So that
even the termination
is under section 106 of the Transfer Property Act. So that.
But if the premises is used for commercial purpose, matter ends.
That was not the issue. That was not the issue before the larger bench on the point of reference. So the only point of reference was whether a termination of a tenancy determined by a section 106 notice would be a commercial dispute or would it be a regular suit.
So it is a commercial.
It is a commercial.
If the premises is a commercial one, suit is maintained in commercial division, why not?
Yes.
That was so we raised that point that was negated. Now there were other points that we had argued in that matter. Those were not answered in the order impute and in that order, and the application was also not disposed of. So those issues have to be hard because
so application is pending.
That is still pending.
So mention it.
And one more thing, I had also filed an application because it's a commercial suit. So I also filed an application for extension of time to file written statement long back, annexing the written statement with the application. Now, because we are discussing and we are arguing on this and then matter went to larger bench, that application is also not appearing in the list. That's second. And third, my clients are in the process of preferring an SLP from the order of the larger bench. Now, the time to file SLP is expiring on 19th of November of this month. The file is been sent to Delhi. They are taking steps and filing it. So I am only seeking that some further time be granted to us to prefer the SLP from the order of the larger bench because it's a point of law.
I cannot. Who am I to grant you time?
Kindly.
I simply may adjourn.
Yes, that is all that I'm saying. Kindly be adjourned.
May I make one humble submission? The order which was referred to the larger bench, that was in the larger bench order was June.
18 June
18 June 20.
Mr. Chan,
On the last occasion, they had made the submission.
Mr. Gupta, answer a very short question. Factually, is he wrong? One. Second, you answer that if part of the demurrer is pending for adjudication, right? Can I take up the summary judgment?
Yes, but there is nothing pending for adjudication. As we are before your lordship today.
No, they have preferred a SLP.
No, they have not preferred. They say they want to prefer. We have checked yesterday also. No special leave petition has been preferred.
I am saying my time to.
And even on 25th of August, even on 25th of August, they had taken an adjournment on the same ground that they will be preferring an SLP. That's recorded in the order.
Certified copy.
That is recorded in the order.
I have got the certified copy. Without that, I could not.
It's an eviction suit. I can understand their strategy.
But what is the strategy? They argued the point of maintenance. My strategy.
I'm adjourning for some time.
This is unfair. Only it is going to larger bench, point of law involved, and it is strategy.
Only one humble submission. Your lordship would kindly hear the demurrer application also on the other points.
Yes.
But because the only one point was referred, which is 106 notice point. Whatever other points, let those be thrashed out so that our application is at least ready for hearing. Because those will not be before the Supreme Court. Subject to what false?
Those will not be before the Supreme Court. That is correct. But I'm only saying, since that was the major point.
Very well, come after some time. After some time, I'm recording.
25th of August, 2025. 25th August.
Kindly record one thing in that order, that I have received the certified copy of the order of
Record. Wait.
the date so that the invitation.
The last দেখুন, series of applications are pending in the instant suit, in the present suit. Full stop. What is your chapter 13A, order 13A?
IAJ Com 3 of 2024.
Full stop. Bold. IA number GA-com/3 of 2024 is an application filed by the plaintiff claiming summary judgment. First. What is your application?
Mine is GA number 2 for orders under order 711 and GA number
IAGA Com 2 of 2024 is an application filed by the defendant
order 711
for dismiss for rejection of plaint.
Defendants.
IAGA Com 4 of
that?
2024 is another application filed by the defendant for
extension of time to file written statement.
extension of time to file written statement. Paragraph. All these applications are pending. Paragraph. Meanwhile, from part of the claim, meanwhile, from a portion, please listen. Meanwhile, from a portion of the reliefs claimed in the application filed for rejection of plaint, the defendant had travelled up to the division bench.
That was referred to
Had travelled up to the larger bench. And the larger bench has decided the issue on which the suit can proceed. First. Today, Mr. Shoroshish Dasgupta, learned advocate, appearing for the defendants. Plural হয়ে যাবে, defendants হবে, হ্যাঁ বাবা?
It should be only for defendant number 1 because that application was taken out only by defendant number 1. That application of order 711 was taken out only by defendant number 1. So that since that issue is
তাহলে ওই rejection of plaint যেটা কি বলেছি ওটা পড়ো ওখানে. So please clarify.
I missed it.
Defendant number 1. ঠিক আছে? পরেরটা filed by extension.
Extension is also by defendant number 1.
Defendant number 1. ঠিক আছে? Next. All these applications have it. তারপরে কি বলেছি প্যারাগ্রাফ? Defendant number 1 has travelled up to the larger bench. Has decided the issue. Suit can proceed. Paragraph. Today, Mr. Dasgupta, learned advocate, appearing for the defendants.
Yes.
Both.
Only one, now only one. Because the other defendant's time, right to file written statement in the suit has expired. Because he has neither.
Defendant number 1.
Yes.
The defendant number 1, appearing for defendant number 1, submits from the order of the learned, from the decision of the larger bench, his client is intending to prefer an SLP. Poster. The certified copy of the certified copy of the order has been received by the defendant number 1 on
the 19th of August 2025.
August 19, 2025.
And I applied in the month of June.
Full stop. Paragraph. The same submission for preferring an SLP was also made and recorded in the previous order dated August 25, 2025.
Could I take your lordship's leave, my lord?
Full stop. Paragraph. Considering the above, this court grants some further time on the prayer of the defendant number one. Paragraph. It is made clear that on the next day, depending upon the situation, this court may proceed with the hearing of the application filed by the plaintiff for summary judgment. Application filed by the defendant number one for rejection of plaint
in the remaining points
on the remaining issues.
Yes.
Post up. Paragraph. All these connected applications shall appear under the heading কিসে আছে? Adjourn motion on December 15, 2025.
Grateful minute for time.
Next. Next. What happened? I have delivered. It's uploaded, the last order.
I haven't seen that. But now that that matter is over, it's correct.
No.
This plaint was. Yeah, that's
neither here nor there.
Look, this one is my demurrer application, GA2, GA1.
Plaintiff.
Your Lordship, I'm led by Mr. Choyan Gupta. He just.
Mr.
Choyan Gupta, he was appearing. He just.
Yes.
I will take some time to address your Lordship on the issue. Well, a suit for recovery of money filed in the commercial division. The point is, if it's a suit for recovery of money, will lie between a NBFC and a borrower if it's on a oral or a verbal agreement. That's the issue. So suit is filed. The plaint case, I'll make out the plaint case. I'll just give the brief. Plaint case is that loan was granted. It was an oral agreement. Based on that verbal agreement, a loan was granted.
Affidavit exchange.
Yes.
Yes.
Affidavit exchange. Yes.
Hey, এটা কি দিয়েছো? It's the attachment of bank account. Order 7 rule 11 আছে. GA-COM? GA-COM?
2 is mine.
Your Lordship. Your Lordship. One prayer, Your Lordship. I have been just.
GA2 listening? কেন? GA2 is not in the list.
Number 15. No, GA2 is 16. 16 is GA2.
16 is GA2.
15 is GA1, 16 is GA2.
তাহলে এটা রাখো 16 টা দাও আগে
Your Lordship.
15 16 একসঙ্গে শুনানি করো
Your Lordship, I would like to make a prayer. Your Lordship, if the matter can be adjourned for today. Mr. Choyan Gupta, he had to rush into another court.
That's right. That's no point. That's no ground.
If it could...
You are there.
It will take me some time to address you.
He will come back. Not to worry.
But anyways, 15 minutes this half. I will take this.
আচ্ছা দুটো মামলা একসঙ্গে অর্ডার হবে ঠিক আছে তারপর লিখবে যে ইনরে GA-COM 2 of IA-GA-COM 2 2021 2020 GA2
GA-COM 2 2021
ইনরে হ্যাঁ এইটাতে অর্ডারটা হবে চলো বুঝতে হবে Where are the affidavits? J2 affidavits.
But we filed a supplementary affidavit too.
Because since this is an application filed by defendant number,
Defendant, solitary defendant.
sole defendant. Since this is an application filed by the defendant, praying for rejection of plaint.
Yes.
Comma, the same is taken up first. Full stop. Affidavits are complete, right?
Yes.
Affidavits are complete. Yes.
We
Tell
have
me.
filed a supplementary affidavit, not Baki affidavit.
Who filed?
We have filed a supplementary affidavit only bringing on record the plaint. There's nothing else from that your lordship needs to look at.
It is.
Which is?
ঠিক আছে। No. Yes.
Now, my lord, if I may just beseech your lordship to look at the Commercial Courts Act once.
No. Second copy. Second volume. Yes.
Your lordship could just have a look at the
Let's
Commercial
see the
Courts Act.
plaint.
Yes. Just Commercial Courts Act once from that, because just be a point of law. The definition of commercial dispute 2CI.
1 second.
Yes.
এটা না একটু এদিকে থাক, তাহলে আমার সুবিধা হবে, তোমরা দিতে পারবে। ঠিক আছে। 2CI.
Yes. Commercial ordinary transactions of merchants ordinary transactions of merchants, bankers, financiers, and traders, such as those relating to mercantile documents, including enforcement and interpretation of such documents. But the plaintiff is an NBFC, so it's a banker.
Ordinary transactions of merchants, bankers,
financiers, let's see, financiers, and traders, such as, this is the part that I'm on, Vinod, such as those relating to mercantile documents, including enforcement and interpretation of such documents. My endeavor would be, relying on how the law has now developed across the country, that simpliciter loan granted on a verbal agreement which does not relate to any mercantile document, far less is enforcement and interpretation, cannot be termed as a commercial dispute. Now, supplementary affidavit, page 7, my lord will find the plaint. There is another aspect to my demurrer. First is that it's not a commercial dispute. If I fail on that, then for revocation of 12A also. This one is a slightly better case than the last one. Page 7 is...
So let's read the plaint.
Yes, please. Page 7 of the supplementary affidavit. Plaintiff is business of investments, granting loan, such as has been registered as an NBFC with RBI.
Yes.
Paragraph 3, your lordship will kindly see. The defendant, sometime in the month of September 2012, approached the plaintiff at the registered office situated outside the jurisdiction through a finance broker, seeking financial assistance and/or a loan. Upon inquiry, the defendant disclosed that he is in urgent requirement of 1.5 crores for his business purpose. It was specifically undertaken.
Where?
Paragraph 3, minute.
3.
Defendant, sometime in the month of September 2012, approached the plaintiff at the registered office.
Acha, 1 second.
Yes. The first qualification it might meet. Once it's an NBFC, banker or financer, it might meet. So I am not urging that.
Yes.
Paragraph 3. No? The defendant sometime in the month of September 2012 approached the plaintiff at his registered office situated so and so through a finance broker seeking financial assistance under a loan. Upon inquiry, the defendant disclosed that he is in urgent requirement of rupees 1.5 crores for his business purpose. It was this line, it was specifically undertaken by virtue of an oral agreement that defendant that he shall repay the loan on demand until the time the same is repaid. The said amount shall bear an interest of 15% per annum to be calculated and paid every 4 months. Such undertaking was given by the defendant in the presence of so and so. So clearly, plaint case it is on the basis of an oral agreement. I'll have to trouble your lordship with 3-4 more paragraphs. No?
You proceed in your own way.
Yes, kindly have a look at paragraph 5. Believing such representations made by the defendant and considering the status of the defendant, the plaintiff made over 1.5 crores to the defendant. The said payment was credited. So, principal agreement verbal, paragraph 3, based on that, this amount, pursuant to the undertaking and the paragraph 6, and agreed terms of the loan, the defendant started paying interest. So, again, the references to that. Seven, your lordship will see. 7 and 8, I really needn't trouble your lordship with.
Paragraph
7, 8 and 9 refers to 3 letters for recalling the loan and for demanding payment. And again, it naturally relates back to the agreement pleaded in paragraph 3. That's a verbal agreement.
The breach of the oral agreement.
Breach of the oral agreement. Standard, how we do on demand. Now, your lordship will have a look at paragraph 9, because I also have 12A revocation, section 12A, not paragraph 9. The plaintiff issued another demand notice on July 29, 2019 through its learned advocate upon the defendant demanding the principal and interest so and so. The said notice has been duly received. Then I'm not troubling your lordship to anything else in the plaint. Then what is outstanding is in paragraph 11. Not paragraph. Hello? Paragraph 14, your lordship will kindly see. 13 is his pleading that I am probable, I'm going to set it out, I'm going to sell. 14, plaintiff has also been able to ascertain the bank account after that.
No, Mr. Banerjee, let us divide the argument in 2 folds.
Yes.
First, straightway rejection of plaint, order 7, rule 11, that it's not a commercial dispute according to you. Then 12A.
Then I'll first concentrate on
Absolutely.
Commercial. Very well. I'm very grateful. Then please have a look at.
Right, Mr. Sen, you will reply in that fashion.
Grateful. Grateful. Please have a look at paragraph 15 now. The only reference that your lordship will find to the Commercial Courts Act is paragraph 15. In the circumstances as pleaded above in paragraph 4, there is an extreme urgency and urgent reliefs are required to be claimed in the suit. As such, plaintiff prays for leave under.
That's precisely for 12.1.
Well, except this, your lordship will not find a single averment in the plaint as to how this is a commercial suit. Under which provision of the Commercial Courts Act does it appear? And the suit is cast on the basis of some length and advance. Reliefs are important, Milord. 1, because it might border and overlap. 19, your lordship will just have a look at once.
No, you proceed in your own way.
No, but it helps me also if I can segregate and argue. The cause of action of the above suit has arisen firstly on February 25th, 2019, when the demand for entire payment was made by the plaintiff, and then on 16th August 2019, when defendant refused to pay. Well, this August 2019 is his demand. 2020 is the suit and 2021 is the injunction application. I'll come back to this for 12-way revocation. Now, your lordship will have a look at the praise in the plaint. Decree for a sum of so and so as pleaded in paragraph 11. Paragraph 11 is
These are the reliefs for usual money suit.
Relief for usual money suit based solely on a verbal agreement, sums lent in advance. Now, whether this is a commercial dispute or not, my lord, I'll just cite one decision because I'll cite two, but one takes care of the entire.
So at the order 7 rule 11 stage, you have to cite a decision which will simply say oral agreement is outside the scope of
That's
commercial.
Just that. Taking the plain to be true and correct.
That's right.
It is said it's verbal. It is not relating to a mercantile document. No transaction.
Mercantile document related or not related depends on trial. But oral agreement, simpliciter, if the law is laid down, that quote unquote, no commercial suit can be filed on the basis of a oral agreement. Then you are through.
Yes. So this is 2021 SCC Online Calcutta 4240.
Once again. 20?
I'll hand it over.
No, that's all right. 20.
21 SCC Online Calcutta 4240. রিপোর্টটা আনোনি ওই তো আছে তো আমার মার্ক করা পুরো ছিল
Yes, Mr. Banerjee.
Just bear with me for a minute, Milord. But instead of relying on that's a reported version of it, can I just rely on the one from the server, Milord? I'll be able to then refer to the paragraphs or at least the page numbers.
No, let us go by the reported one.
Yes.
I don't mind. You just keep both side by side and compare and give the reference of paragraph.
That's my difficulty. I'll start placing from this note. I'll take it out in a minute.
No. পাশাপাশি দুটো রাখো বাবা প্যারাগ্রাফ গুলো মিলিয়ে বলো কোনো অসুবিধা নেই Take your own time and read, no problem.
The present application is for return of the plaint and for dismissal of the suit. The issue which arises for decision is whether the suit filed by a commercial division of this court should be tried under the provision of the Commercial Court Act or is to be heard as a regular suit. The plaintiff complains about the conduct of the defendant in not filing the written statement and seeking to take advantage of such so-and-so. The division may insist. The third line, your lordship will see, the claim in the suit is for recovery of money advanced by the plaintiff to the defendant as a short-term financial accommodation with an accrued rate of interest. The plaintiff has claimed the decree for 64 so-and-so. The defendant vigorously argues that the suit cannot be classified as a commercial suit as the dispute between the parties is not a commercial dispute as defined in commercial dispute has been defined under so-and-so and then it takes care of the section, Milord. And then 21C1 is again quoted. Now the next paragraph after that. In order to ascertain whether the dispute qualifies as a commercial dispute within the purview of the Act, it is necessary to break down the classes of persons and transactions contemplated in the said clause. Clauses 2 to Roman 12 do not apply in this case. The construction of 21C falls for consideration. Ordinary transaction of merchants, bankers, financiers, and traders. Well, this part, your lordship will kindly skip, except I'll only the
suppose just one question here. Forget about NBFC. Mr. Shuddha Sattva Banerjee lends and advances for whatever reason to Mr. Somriddha Sen X amount.
If he returns it.
If he does not return, I'm not coming to the oral transaction for the
No, I
time being.
understand. Let's say there's an agreement.
If he does not return, can you not maintain a simpliciter commercial suit?
No, I can file a normal suit for recovery of money. It will not become a commercial dispute.
Why?
Because for it to become a commercial dispute, I will either have to be a merchant, banker, trader, or financer as a part of my business.
Right. So I am saying as a financer, you have advanced. You are not an NBFC.
No, as a financer also, then I must show that
Whatever license
So
or
this is
whatever
part-
permission is
this
required,
is
you
that
have.
paragraph I wanted to show. This query that your lordship has put to me is the first paragraph. Because then should me giving him as a lawyer because he sits at my table doesn't make me a financer.
Absolutely. I am saying a financer.
If I am a financer, then then it will be commercial suit. But it will be a commercial suit if there is a document. There has to be a mercantile document. Simpliciter verbal agreement for loan will not, because the suit must relate to a dispute which relates to a mercantile document. Whether in every suit your lordships have, a landlord suing tenant.
Suppose all right, I will see to the plaintiff with its all documents. What are the documents they have relied upon?
That he's lent money. That I showed
No,
you.
no. What are the documents? I'm not on pleading.
The
Documents relied on upon in the plaint.
Statement of account, money gone from me to him, and his registration certificate, his details, acknowledgement of payment, balance confirmation that I'm giving to him, and copy of the letter and notices. It's not a mercantile document. Well, this judgment.
Right. You proceed. Let us come back.
Yes, but today at 2 or tomorrow.
Tomorrow হবে না, তাহলে আবার সরে যাবে। তাহলে সরে যাবে পরে। Adjournment I don't mind, but আমি ওই consecutive adjournment হ্যাঁ yes, show me the last interim order. আসুন।
The division bench order was handed up in the morning.
We just extend the last 17th September.
There is an order of the division bench after this by which the ad interim order, which was extended by this order, was substantially modified.
Your Lordship will
I
have
don't know
to.
what remains now.
Your Lordship will have to say.
Which is made, and kindly see the division bench order. Your Lordship will not see only the extension order, because the extension order does not.
Your Lordship will kindly provide as modified. End of the matter.
Yes, noted. You can kindly see what the interim order was, because now your Lordship is being. It cannot be a simplicity extension. Your Lordship will have to pass an order.
My learned friends have not yet filed an affidavit.
Make an order. Simplicity extension may not be appropriate.
So where is the interim order in the
Kindly
division
see
bench?
the interim order once, please, my lord, of 19th August. I'm not sure whether it's been handed over.
Kindly show me from the division bench, last division bench.
This I handed over to your lordship, my lord, the order of 3rd
November.
This is the order by which the appeals were disposed of.
And the appeal court matter at page 4 of the order.
The appeals were from the order of 19th August 2025.
There were two appeals, one from the order of 19th, one from the order of 17th.
No, but to what extent it was modified?
Well, that is at
the lordship
page.
is required to see the first order which was made, of which my learned friend seeks extension. Has your lordship been given a copy of the order of 19th August?
Well, is my learned friend contending that the interim order cannot be extended or it does not survive?
Not in the manner in which it was made.
So therefore, my lord, what am I praying? I am praying that, my lord, let the order be extended as modified.
Your lordship will
Otherwise,
see
I
what
will
the
be
order
without
was.
protection.
I don't find any interim order in the order of division bench.
No, my lord, it has only said in such circumstances it would be
final order
appropriate
of
to
disposal.
modify the order impugned by permitting the appellant to press its application.
Correct.
Now, my lord,
where?
that's page 4. Page
In
4,
such
second paragraph.
circumstances, it would be appropriate to modify the order impugned by permitting the appellant to press its application under section 7 of the IBC before NCLT.
That's right.
NCLT will not note out and decide such application in accordance with law.
That's right.
And kindly see the 2 paragraphs after that also, please, my lord. All points raised by the parties with regard to the proceedings under section 7 are to be decided by the NCLT. Kindly see next. It is clarified that the legality, validity and sufficiency of the recall notice and the follow-up notices may be decided upon the NCLT if so raised to the extent of recalling the loan.
My lord, may I
Now
clarify?
kindly see the interim order which was made.
No, my lord,
Because
may I clarify?
coming in the way,
I don't understand what is this, my lord,
order.
objection.
Your lordship will make an order.
I can argue the matter again.
Let us argue of the matter.
Well, I don't understand what my learned friend is saying.
Let me pass my order. You
Yes.
both of you hear.
Yes.
Then if you have any submissions, I will hear you.
Please, ma'am.
The original interim order was passed by a coordinate bench on August 19, 2025. Unish. Which was extended by an order dated September 17, 2025. Full stop. The defendant paragraph, the defendant, sole or many.
No, the defendant numbers 1 and 2.
Who preferred appeal?
Well, 1 and 2.
Both 1 and 2.
Both the defendants.
No, there are more than 2, my lord.
Acha, the defendant number 1 and 2 preferred an appeal, being APOT 252 of 2025.
Preferred appeals. My lord, preferred appeals. There were two appeals. Your lordship.
Appeals.
Yes, because there are two APOT numbers your lordship will find.
Being APOT 252 of 2025 and APOT 282 of 2025. Full stop. The Honorable Division Bench, paragraph, by its order dated November 3, 2025, has disposed of both the appeals with the following observation. Quote 1 from page 4. Full stop. Full stop. এখান থেকে এই অবধি দিদি paragraph. Today the matter has been mentioned at the instance of the plaintiff seeking extension of an interim order which was initially passed on August 19, 2025 and then was extended by an order dated September 17, 2025. Full stop. Paragraph. By placing the matter in the supplementary list, the same has been taken up for consideration. For a limited purpose of extending the interim order as contended on behalf of the plaintiff. Paragraph. This court finds that after the order passed by the Honorable Division Bench, there is no scope for extending any interim order any further, as the observation of the Honorable Division Bench is already there, and the same is in force. That's all. And the same is in force.
My lord, kindly see, my lord, one thing. But so far as this is concerned, my lord, that appeal was from an ad interim order.
Mr. Shah, I cannot touch. If no,
I'm not asking your lordship to touch, my lord. I'm only saying that, my lord, the appeal that was preferred, appeals that were preferred from two ad interim orders. Now, my lord, so far as the ad interim orders are concerned, the ad interim orders, my lord, were orders of restraint, my lord, in restraining my learned friends from proceeding to, my lord, initiated proceedings in respect of, my lord, pledges and mortgages, which is beyond the purview of the NCLT. My lord, to that extent, my lord, this order survives. My lord,
after whatever is there in the appeal court observation I have quoted, that remains.
My lord,
then if you need further clarification, apply before the appeal court. That's not within my domain, sir. After this observation, that's not within my domain.
My lord,
কি বলেছি?
My lord,
active, huh? Any interim order. Bas. Observation of the division bench is in force, I have said.
The observation of the division bench has, my lord, said that, my lord, the main petition will be disposed of because your lordships had given directions for filing affidavits, which is
Then
not.
you have to apply before the division.
May I just,
My lord,
since
only
we are
thing, my lord,
troubling you today, my lord, kindly
my
give
lord,
me an
kindly see.
extension to file an opposition, my lord.
My lord,
and file it
my lord,
within a
kindly
few
see, if
days.
my learned
Kindly
friend wants
fix the date.
extension of time to file opposition, I will be without the interim protection.
That is there.
Mr. Shah, whatever is there before the division bench, I cannot go
No,
beyond
no,
that.
my lord, I am not asking. My lord, what is my prayer before your lordship? my lord, interim order be extended.
Your prayer is,
interim
sir,
order be extended as modified by the division bench.
I do not, I have quoted that. I say that nothing is required to be done by this court. As that observation of the division bench is still there and in force.
But my lord, the observation of the division bench in respect of the impugned order. The impugned order is limited till 11th November.
But no, that is merged with the division bench because 17th September has been taken care of by the division bench.
Those were the two
Kindly
appeals
see.
by
Well, in that case, kindly make it clear since the impugned order has now merged with the division bench.
I will not make any comment, sir. I will not make any comment. Kindly take the appeal court order, sir.
Yes.
If you, sir, after that you suggest to make me those comments, can I? Kindly turn to page 2, first paragraph, sir. Read loudly.
Yes. My lord, advocates for the appellant submits that the interim order.
No, first paragraph, sir. Page 2. Page 2.
APOT is directed against order dated 19th August, passed in such and such. As is directed against the ad interim order dated 19th August, which was extended by order of 17th September.
That ends. Now 17th has merged with the appeal court. The direction is of the appeal court. I cannot.
That's why there were two appeals. Like what?
Mr.
I know, man. That's why it's just bring.
Why? I have made my order in open court. If you have any submissions contrary thereto, as Mr. Shah has.
I have no submission. I have
He
only
may
one
make his
prayer.
submission, but
I have only one prayer. Kindly extend the time to file my affidavit.
Well, I am opposing that. I am opposing that prayer because my learned friend has, my lord, has to, my lord, make a formal extension application. And my lord, so far as this is concerned, kindly see, my lord, when the directions were given. Kindly see, my lord, from order 17 and 19.
That is all right. That you can take the plea. That you can take the plea.
Yes, my lord. I kindly place it in the list, my lord, for hearing.
No,
my learned friend has.
That I cannot right now. Whenever the list will permit, sir. Ashud.
Kindly permit.
Since it is submitted by Mr. Krishna Raj Thakkar, learned senior advocate appearing for the defendant.
1 and 2, my lord.
1 and 2, that time to file affidavit in opposition stands expired, comma, and he prays for an extension, comma, time to file affidavit in opposition stands extended till November 28, 2025. Affidavit in reply, if any, thereto shall be filed by December 17, 2025. Poster. The matter shall appear in the list under the heading Adjourn Motion on December 22, 2025. Mr. Shah, what happened to that matter? Any SLP carried out? That during this vacation, that 227?
No, that an order rightly passed. No, well, now that the matter is over, I can, my lord, tell you, lordship, but my lord, I told them that no point in carrying any appeal from.
Thank you so much.
My lord, ultimately, at the end of the day, after, my lord, all we are officers of court, my lord. We argue
so
out,
much.
then, my lord, we understand what is the matter.
Thank you so much. Yes.
No. 15, 16.
Okay. Place the judgment. Start.
But can I very honestly say something? That I'm avoiding the mic. That I did not go to Alipur to do this matter here.
Huh?
I did not go to do a couple of other matters to do this matter. If I do this from 2 o'clock, while doing a commercial suit, it's going to become extremely commercially unviable for me.
No, I don't mind, but it will not be kept soon. I don't mind, sir. Giving adjournment, I'm absolutely, you are welcome.
When I went out, series, it will become very difficult for me.
No, I don't mind, sir, but then it will not appear very soon. The others will get chance.
Any particular day?
Could we come back next week, my lord? Because my application is there. That is why, my lord.
No.
I really can't oppose him, but since my application,
He also knows how many are missing.
I also appreciate. I feel the pain. I am still. I feel for you. I feel for you. But then you take adjournment, I don't mind, but not very soon. Others will have to get preference.
December any date? This has gone on from 21. So it will be unfair on my part if I'm seeking an adjournment to push it to be kept this month. Next month, any date? Any date next month. Lordship will not take me amiss.
No question. Absolutely not. But I mean, next lot will have to be given a chance.
Next month, any date your Lordship will give me.
Why should I take you in this? Absolutely not.
He was very jittery making the submission. Told me outside the court. I said, "You please pray to my Lord."
In fact, it was his idea to come and be
No,
honest.
but the juniors must go up.
The others who are.
Yes, the juniors. You're junior in this matter.
He is busier than me.
Maybe. So the juniors must go up. Juniors must go up. Like in the last matter, your junior did excellent. Excellent. Excellent.
In fact, I'll go back and tell him this one that your Lordship has again said it. It's
He's
a
done
huge boost,
very
for,
good.
including for us if we hear it.
Very
from
good.
court.
No, you have crossed that stage, but these juniors must do. Juniors must do. And I assure all the juniors, if I hold ultimately against them, I will definitely hear his senior. Unless it is so expressly bad case.
That before this bench, none of us have that.
Absolutely, absolutely.
That is something that we also know.
Absolutely.
That will never happen.
Absolutely. And I am satisfied so far my conscience is clear. I have granted hearing to both the sides. I may commit mistake. Does it matter to me? I will be corrected by the higher forum. I don't mind for that. কি হয়েছিল? Paragraph. Mr. Shuddha Sattva Banerjee, Learned Counsel, appearing for the how many?
Defendant.
One. Defendant has been placing his case on his demerer application. Full stop. He has started citing a decision of a coordinate bench in the matter of Didi. লিখে দিন 8টা ভার্সেস 8টা যেমন আমি লিখি in the matter of italics bold reported at 8টা reported at আমি লিখি হ্যাঁ আমি in লিখি না reported at
পরেরটাতে কি করবো কিছু মনে নেই কোনটা এটা কোন মানে হচ্ছে যেটা দেখ এটা কি অনেক ছিল এটা ঠিক আছে
Paragraph. At this juncture, Mr. Banerjee prays for an accommodation. Prays for an accommodation. Mr. Paragraph. Mr. Choyan Gupta, Learned Counsel, appears for the plaintiff. আগে লেখা থাকলে আর লিখবেন না এটা ফুল স্টপ দরকার নেই লেখা ছেড়ে দিন Paragraph. For the ends of justice, the hearing stands adjourned. Full stop. Mr. Banerjee shall commence his submissions on further commence his submissions on the next day. Now, Mr. Banerjee shall continue with his submissions on the next day on his demerer application. Full stop. The matter shall appear under the heading. Key heading আছে?
Adjourn motion.
Adjourn motion on December 15.
I'm very grateful.
2025. make it very clear your junior will do. Yes, whoever is there has to do.
But one thing, with 20 years of experience, I'll muster up enough courage to say this. But your lordship's temperament is a huge advantage to the bar. Huge advantage. With a lot of responsibility, I'm saying this.
Chal.
I'm very grateful.
The way your lordship said that if I'm against some junior, I will not dismiss hearing the senior, that itself gives a big confidence.
Not always.
No.
If I face such a bad case.
No, that's a separate thing. But generally, that
no.
Very, very kind.
At the end of the day, both Mr. Gupta and Mr. Banerjee, at the end of the day, for last 5.5 years experience on this side and 22 years on that side, I have realized it's really, at the end of the day, exchange of intellect between the two sides. Nothing more than that. Nothing more than that. Exchange of ideas, exchange of intellect between the two sides. Nothing more than that. You will explain in your own way, merchandise document. I will think in my own way. He will explain in his own way. Then whatever good, bad, ugly, indifferent, I think I will hold. How does it matter? Thank you. And I will also tell you, for last 5.5 years, the cooperation and assistance I received from the bar, and I have been receiving, amazing. Amazing. The assistance and cooperation from the bar. Amazing. For last 5.5 years. Every time, in every matter.
Very kind. Item number 17. Which item number 8?
Lord, I appear for the
আচ্ছা ওইখানে দুটো ছিল না আগেরটা দিদি 15-16 একসঙ্গে
Mr. Devnath Ghosh is appearing, my lord. Mr. Devnath Ghosh is appearing for the defendant, my lord. I'm praying for not today, my lord.
Passed over for the day.
19. Yeah, trouble.
19 হ্যাঁ তো মিসেস কি একটা রয়েছে না ট্রাভেল হ্যাঁ
In item number 19, I appear for the insurance company, defendant number 2, my lord. And only one problem, my lord. In 2007, your lordship, a person had entered appearance by filing the Vakalatnama. One Mr. Shopon Kumar Dotto. Now, my lord, subsequently, the suit was not there in the board of the court. My lord, the insurance company has asked my advocate on record to appear again. So, my lord, when I approached the erstwhile advocate on record, he was not found. We tried to contact him over the telephone. He was not picking up phone. His phone was not responding. So, my lord, I'm praying for leave to at least file the Vakalatnama and enter appearance. And with competence.
There is one provision in the original side rules. Perhaps you have to take out an application. Consult the rule. There is one provision I faintly recollect. In such a situation, there is a provision you have to apply in chamber, and whatever prayer you have, consult that provision. Find it out. Ashun, on the prayer of Mr.
Balarko Sen. Balarko Sen.
Balarko Sen, learned advocate, appearing for the defendant number 2. Since there is some procedural aspects to be cleared out. Procedural aspects to be cleared out, the matter shall appear under the heading adjourn motion in the monthly list of February.
No, that is for that limited purpose, because I'm appearing for the plaintiff. There's an application taken out by the defendant number 1, which is GA Com 8 of 2024, for recalling of an order passed by the Honorable Court.
Defendant number 1 is not represented. Yes.
But the only reason I'm making this prayer, it is their petition, my lord. They have been taking time. So today, my lord, if they don't move this application, my lord, I'll be pressing for dismissal of that application. I'll tell you, lordship, why. The matter was, my lord,
originally transferred from
You have taken out any application for
They have taken. They have taken out this application, Lord, but they are not moving this
application for what?
for Lord, recalling of an order.
So how does it matter to you?
Lord,
How
because
does it matter to
the
you?
main proceeding is stalled. I'll tell
Why?
you, Lordship, why.
Which proceeding? Suit.
The entire suit, my lord, because
Why?
they are praying that the order by which, my lord, this was transferred from non-commercial division to the commercial division has to be recalled, and the matter has to be relegated back to the non-commercial division, and that is pending.
Not a commercial dispute. This is
আচ্ছা ওকে এটা আগেরটা লিখুন your application in Ray
Want to enter appearance by filing new wakalat.
কি বললাম না the matter shall appear দেবে না the since না কি বললাম বলার কোসেন না সিন্সটা কেটে সিন্সটা কাটুন তাহলে কি লিখবেন পড়ুন আরেকবার অন দ্য প্রেয়ার কেটে দিন লিখুন Mr. Bolak, Mr. Bolako Sen, learned advocate appearing for defendant number 2 submits that the erstwhile advocate on record for his client has not been responding and taking any steps in the matter. Full stop. Unless the proper no objection is received by the present advocate on record, no objection is received from the erstwhile advocate, no fresh wakalatnama can be filed. As such, the interest of the defendant number 2 in the suit is not being represented. Very well. You proceed with your application. No adjournment. He is opposing.
Kindly keeps it tomorrow.
No adjournment. He is opposing. Convince your learned friend, but it will go out.
My learned juniors are appearing, so
but
I
it will not be taken up tomorrow.
I leave it to your lordship. If
Next week, my lord.
your lordship knows me, my lord, I'll be the last person.
Next lot will be given preference.
On human rights, my lord.
Whoever, doesn't matter. Doesn't matter. You have to proceed. Proceed with the application.
One more thing. We have not received the copy of the amended rate. It has been transferred from the non-commercial.
Sir, you have no right of audience today. That's the difficulty. Full stop. Mr. Pronit Bagh, learned advocate appearing for the plaintiff submits that GACOM 8 of
2024.
2024 has been filed by defendant number 1, which is an application praying for removal of the suit.
Recalling of an order of March 1, 2020.
Removal of the suit from the commercial division. Full stop. Paragraph. After the said application is required to be heard first. Very well. I'm not. You just come tomorrow.
I'll be the last person to, my lord, oppose if, my lord, my learned juniors
that's
are
all right.
appearing, so I will not do that.
Come tomorrow.
Only because they are appearing. I will
Order
not.
লেখারই দরকার নেই. Come tomorrow.
Keep your point.
Passed over for the day. But madam, if it is, if no adjournment and no Passover prayer will be entertained tomorrow, you have to do it.
Keep your point. Yeah.
Yes.
There are four applications. I appear for the plaintiff.
One is my application for interim release of injunction, that is GA1. And GA3 is my application for judgment on admission. GA4 is my learned friend's application for reference of the parties to arbitration, section 8. And the last GA is for production of the arbitration.
Section 8, come on.
Yes, section 8 was heard first, was being heard.
Yes, my lord. So this
In
was
way, GA?
GA4.
4 of, GA com 4 of?
GA4 of 2024. 2024.
2024. Come on, proceed. Affidavit exchanged?
Yes, my lord.
No.
My lord, we had entered into a distribution agreement with the plaintiff in this case. My lord will find the distribution agreement.
Show me the agreement.
Yes, my lord. This is at page 140 of the section 8 applications.
Arbitration Conciliation Act দাও বের করেছো সম্ভবত কালকে এগ্রিমেন্ট পেজ
140 my lord.
আমার কমার্শিয়াল কোড একটা গেল কোথায় এখানে আছে তুলে দাও পেজ
140
140
of the section 8 application.
140
140.
Yes.
My lord will
Yes,
see
sir.
the first page itself. It's a distributor agreement.
Show me the arbitration clause.
Yes, my lord. The arbitration clause is at page 129.
Huh? 140 the agreement starts and 129.
I apologize, my lord. It's at page 148.
One. Distribution agreement starts at which page?
140, my lord. And the arbitration clause is at page 150. Article 12, my lord.
Yes.
Now, my lord will see Article 12 states that in the event of disputes arising in connection with this agreement, the parties shall endeavor to reach a friendly settlement. All disputes arising out of or in connection with this agreement shall be finally settled under the rules of arbitration of the ICC, that is the International Chamber of Commerce, by one or more arbitrators appointed in accordance with the rules. The place of arbitration shall be in Amsterdam, Netherlands. All proceedings shall be conducted in English language. This is the arbitration clause, my lord. Now, my lord will kindly come to page 140. I just want to indicate one thing regarding the identity of the parties to this agreement.
Yes.
My lord will see it is a distributor agreement between Flint Group Print Supply.
Flint is the plaintiff.
It is the holding company of the plaintiff, my lord. So, my lord will see hereinafter it is referred to as Flint Netherlands, and the plaintiff here is a company called Flint Group India.
Mr. Counsel, who are the plaintiffs? Show me the plaint.
Yes, my lord. The plaint starts from page 13 of the application.
13.
Yes, my lord. It is a company called Flint Group India Private Limited.
Yes.
Now, my lord, we had
Show me
entered.
the law that if the holding company's plaint is there,
Right.
and the arbitration agreement with the subsidiary, it's binding.
The arbitration agreement is with the holding company.
Very well. The reverse.
The distribution was happening. We were constantly in touch
You
with the
show me
subsidiary
that
company.
the agreement, Mr. Counsel, Mr. Full name?
Charbesh Chaudhuri.
Mr. Chaudhuri, X and Y are the parties.
Yes, my lord.
To the arbitration agreement.
Yes, my lord.
The suit filed by Z. Suit filed by Z, maybe holding, maybe subsidiary, whatever. An independent juristic entity.
Right.
You show me that it binds the Z.
My lord, I'll show you this judgment of Cox and Kings by the Supreme Court. My lord, I'll kindly show you the paragraphs. The twin tests is if there is a commonality of subject matter and if there is a composite nature of transactions. In such cases, the holding company or such non-signatory can also be bound by the arbitration agreement, my lord. And this is precisely what I'll endeavor to show before you. There's correspondence which is attached with this application, which will show that the holding company, the subsidiary company, and my client, which is the distributor, all three were constantly exchanging correspondence to show that there is a commonality of subject matter, and there is.
But if there is a matter of the questions to be decided on trial, whether commonalities, whether the transaction, nature of transaction in a plaint as pleaded, and if denied by in the written statement, it's a tribal issue.
I can understand my lord's apprehension in this case, but ultimately it's a Section 8 reference.
Correct.
And there is an arbitration agreement.
Correct.
So if there are parties who have already signed an agreement and because
parties,
of the...
I agree. I agree. Parties who have signed the agreement. I agree. Parties, I agree. In conformity with Section 7 of the Arbitration Act. I agree.
And you show from your iPad, no? Soft copy that, Cox and Kings.
If there is a
No, no, এটা তো Delhi High Court একটা 2024 এটা yes so paras মাত্র আছে নাকি leave নে আমি বল
My learned senior will assist me in this.
Yes, yes.
My lord, plaint filed
this
by
matter, yes.
Plaint filed by A against B. A and B, his case is there is no arbitration clause in the contract between A and B. My case is, my lord, in the 5.8 application that A is, my lord, a subsidiary of X. X has a contract with B, which has an arbitration agreement. A is bound by that agreement. I want your lordship to invoke the group of companies doctrine to hold that a 5.8 application is maintainable and refer the disputes to reference. My lord, this is, my lord, sum and substance of my case in the 5 and 8 application. What is the objection?
Lock, stock and barrel with all the parties.
With all the parties. What is his objection? His objections are twofold. First, which lordship initially, my lord, indicated to my junior, that how can there be a reference when the parties are not named in the contract. That's the first objection which he has also taken. To that, my answer would be the group of companies doctrine. His second objection is that there was an agreement between his client and my client, which he has pleaded in the plaint, which agreement did not contain an arbitration clause. Therefore, no 5.8 is maintainable. That's his second objection.
His objection principally is between plaintiff and defendant, there is no arbitration agreement.
Right. That's his principal objection. And his
so
plaint
you satisfy me that on the basis of this objection, your 5.8 is maintainable as you will be content.
Yes. So I want to show, before I take your lordship through the law, I want to show few, my lord, factual aspects of this matter, because affidavits were directed to be exchanged to the 5.8 application, where in reply we have disclosed documents which remains uncontroverted. Documents exchanged.
No, Mr. Dotto.
I am conscious that lordship has to see whether the subject matter of the plaint.
You have to take me through the plaint.
Yes, I will.
Do that.
Please come to the, my lord, plaint first. Let's start with the plaint, my lord,
yes.
page 13.
That's right.
My lord, kindly comes to the parties. First is Flint Group India Private.
Flint Group
Yes. Yeah.
India versus Sujoy Loda. Then take me to the Flint.
Yes. Kindly comes to the first paragraph.
You are the
I am
you are
defendant.
Sujoy Loda.
Yes, I am defendant. Proprietor of SAS India. It is the proprietor. Sujoy Loda is the sole proprietor of this entity called SAS India, SAS India. Now his first paragraph kindly takes note of only one, my lord, averment. Plaintiff is engaged in the business of manufacture and sale of printing, inks and allied products. He describes defendant.
Plaintiff is an existing company.
No, just after that, my lord, 5 lakhs. After the
Plaintiff is
6 lakhs.
engaged.
Yes. It's his business. Manufacture and sale of printing, inks and allied products. I'll show, my lord, the connection between the, my lord, holding company and the plaintiff company with regard to the business. And I will also establish from the documents that he was actually acting as, my lord, an affiliate of the holding company with whom I have the agreement, the arbitration clause. The defendant is the sole proprietor of and carrying on business under the name and style of SAS India. From his office at so-and-so, that is not really relevant. Now kindly comes to page 15, paragraph 3. 3, 4 and 5 is really, my lord, important for the purpose of agreement. This is his plaint case. Pursuant thereto, parties entered into negotiations and discussions during which the terms and conditions for the supply and or delivery of goods and payment were duly agreed upon. It was agreed that defendant shall place verbal as well as written purchase orders on the plaintiff, and upon receipt thereof, plaintiff shall cause delivery of the ordered goods from the plaintiff's godown at such and such to the defendant's office godown at such and such. Then paragraph 4. It was further agreed upon by and between the parties that immediately upon delivery of the goods, the plaintiff shall raise appropriate invoice on the defendant, and upon such invoices being raised, defendant shall make payment against the same within a period of 90 days from the date of each of the invoices. In default of such payment, outstanding amount would carry an interest of 18%. Aforesaid discussions and negotiations took place, and agreement was concluded at the office of the defendant situated at blank, situated at Lenin Charoni so-and-so within the jurisdiction aforesaid. Para 5. Apropos such agreement between the parties, defendant placed orders on the defendant from time to time, on the plaintiff from time to time, on and from March 2022. So, my lord, these are really the 3 paragraphs with regard to the agreement. He does not give a date of the agreement. He says this is an agreement between the plaintiff and the defendant. And with this, my lord,
Might be even oral agreement.
I proceed that it's an oral agreement. I proceed on the premise because his plaint does not, my lord, expressly say that it's a written agreement, and the tenor of the averment suggests that it may be an oral agreement. Now, my endeavor is to show that this oral agreement, or whatever may be the form of the agreement that the plaintiff has entered into, was on behalf of the Flint Netherlands, which is the holding company. Even the plaintiff was aware of that because of the, my lord, correspondence which I have disclosed in my
So it is a matter of trial.
No, it's not. It's not, my lord. At the, my lord, 5-8 stage, I am conscious that I cannot invite your lordship to, my lord,
any tribal issue
thing which is triable. I cannot. But on the face of it, if I can show, my lord, documents, my lord, this is important. Why I say this? When I was permitted to use a reply to their opposition, I disclosed few documents exchanged between Flint Netherlands, Flint India, as well as Sujoy Loda, that's the defendant. And from those, my lord, exchange of correspondence, it would be, according to me, evident that there was this agreement, distributor agreement, which is the main umbrella under which this entity was functioning as a selling affiliate. And in exercise of that authority granted by Flint Netherlands, he had entered into whatever may be the form of agreement with me. Now,
if you ask me precisely, according to me, to hold a prima facie view at least in 5 and 8 application, affidavit is not required.
My lord, there may be a situation, hypothetical, where, my lord, a party files a suit. A lordship is now having the determination of the commercial division. there may be, my lord, in the regular division, there may be a suit where we are not compulsorily required to, my lord, disclose all documents with the plaintiff. And there is no that fixed timeline thing is also not there, those rigors. So an agreement may not have been disclosed with the plaintiff. And the plaintiff may proceed on the basis of an agreement with the date of the agreement mentioned. If I don't, my lord, disclose the agreement by way of an affidavit, when I am opposing or when I am moving a 5/8 application, my lord, possibly, my lord, the court will not get a chance or an opportunity to look at the, my lord, arbitration clause, because the plaintiff does not have that. So the application is necessary. Dealing with that application,
No.
he may say,
No, Mr. Dotto. The
I did
major
not-
difference
I
is
did not
that
complete. I did not complete. I know, my lord. I heard your lordship's query. My lord, dealing with, my lord, that case, the plaintiff may come up saying that, look here, this agreement was novated. This agreement was novated by a subsequent agreement which did not contain an arbitration clause, and here is that agreement. And that subsequent, and parties by have acted in terms of that subsequent agreement. So that's the reason possibly where, my lord, scope of affidavits are important. Not in all cases that affidavits are required, lordship is possibly correct. But at times, my lord, affidavit may give your lordship a better picture of what the, my lord, factual, my lord, backdrop of the matter for that. Now, when the court, my lord, this court had permitted affidavits to be exchanged, this court also permitted my learned friend to use a rejoinder to this reply affidavit. Why? Because I disclose documents to suggest that there is an agreement between the parties and you are bound by your holding company's agreement. He chooses not to, my lord, dispute that.
if he is ultimately, if you succeed to prove that this agreement is nothing
but a fallout of the original distributor
parent agreement,
yes,
then his suit will fail.
His suit will fail. So, my lord, his suit cannot continue here because my contention is because of that arbitration agreement, and I will try and convince your lordship to hold in my favor when I cite these authorities, because it is not for the first time that this point is being urged. This concept was urged and accepted by courts. Even our High Court, I will show the Supreme Court.
Even Sukarna Holding.
Yes.
Sukarna Holding.
Yes. That has also been considered in the latest decision.
The Sukarna Holding was the first case.
So I will try and demonstrate, my lord, that he cannot bypass the, my lord, agreed mechanism of settlement of disputes just because it may be expensive to go to Amsterdam and fight a litigation. We may want to go to Amsterdam to fight a litigation. Now, my lord, let me just complete the...
With a great smile. If a chance comes.
If a chance comes, yes, of course. Who will not smile, my lord? My lord, then paragraph 6, my lord, he refers to the, my lord, transaction that goods have been sold. The suit, my lord, claim in the suit is on account of
Goods
unpaid
sold and
price
delivered.
of goods sold and delivered. That's the, my lord, claim in the
I've
suit.
seen that. Goods
Yes.
sold and delivered.
Then, my lord, para 7, he refers to the invoices. And then, my lord, paragraph 9, my lord, 1 crore 6 lakhs and all.
You show me a single sentence from the plaintiff where the plaintiff has referred to that parent agreement.
That is not there. I cannot show, my lord, what is not there, but I will otherwise convince your lordship. Try to convince your lordship.
Correct.
যে অ্যাডভোকেটের ডিলারশিপের কথাটা এগ্রিমেন্ট বলেছে
কোন ডকুমেন্ট বার কর
Or that he has pleaded in the plaint an iota of involvement of the other entity with whom there is an arbitration clause.
Yes, that I can show. Not in the plaint as an averment, but from the documents exchanged.
Sir, then again it's matter of trial. I cannot look beyond the plaint.
My lord is having a very... My lord is thinking that the jurisdiction will be very restrictive when your lordship is trying a 5/8
Of course,
application.
subject to reading this judgment.
I will, my lord, try and, my lord, persuade your lordship to hold otherwise. That apart from the plaint, now, my lord, even in the cases of Order 7, Rule 11, courts have clarified that even the documents appended to the plaint to see whether the plaint discloses a cause of action or not, the court is, my lord...
Discloses a cause of action is something
No,
different.
my lord, the classical, my lord, position as we understood, my lord, initially was that you have to restrict your challenge to the 4 corners of the plaint to suggest that it does not disclose cause of action.
On a reading, it does not.
And you can't, my lord, travel beyond the, my lord, plaint averments. Now that position has been explained and clarified further
that documents can also be looked into when a court is hearing a Order 7 Rule 11 application. And that
Question
is the
is-
strictest form of a demurrer application.
I accept. But question is, when 5 and 8 adjudication, the first rigor is Section 7 of the Arbitration Act.
Yes.
First rigor. First rigor is the Section 7 of the Arbitration Act, which is the basis of 5 and 8.
My lord, I take it, my lord, it is, I will satisfy Section 7. But kindly, my lord, bear this thing in mind, that 5 and 8, Section 8 does not say, the statute does not say that the plaintiff has to talk about an arbitration agreement. Then there would be no 5-8 application. Or a reference to the, my lord, arbitration clause.
Not required.
My lord,
but if the plaintiff shows, the averment shows repeated reference of the entity with whom an arbitration agreement is there, then the situation would have been different. Now, second way to look at it from your angle, from the point of defendant, if that agreement is so essential that without which he cannot prove his case, which contains an arbitration clause with a third entity, then automatically his suit will fail if he has not pleaded.
my lord, this whatever has now fallen is on merit. I may have a very good case on merit. I am trying to convince your lordship that a plaintiff who is avoiding.
I'm replying to your query. I'm replying to your submission, not query, submission. You say that you will try to convince the court that the case made out in a fashion which essentially involves that agreement.
And in a fashion to avoid that arbitration agreement, this suit has been.
Sir, if ultimately he has to rely on that agreement containing arbitration clause.
My lord, he may not have to. He may not have to. Because when
then why
kindly
the suggestion of the defendant?
No, my lord, kindly, I know.
Then not a
and today, my lord, there is, let me also clarify this, there is no written statement in this suit. Being a commercial suit, I lost my chance. There's no written statement. So even if this application fails and the suit proceeds for trial, at best I cross-examine him to disprove his plain case. To disprove his plain case. Otherwise, I cannot suggest something which is not there. Now, coming back to the 5.8, my lord, provision, my lord, Section 5.8, my understanding of the provision is this, that a defendant in a suit who says that the subject matter of the suit is covered by an agreement between the parties or parties claiming under somebody else, which contains an arbitration clause, has to be referred to reference to an arbitration. This is my understanding.
So let us first read the judgment.
Very well, my lord. Let me start, my lord, with the Cox and King judgment. Copy. My lord, kindly comes to straight away paragraph 87, where the group of companies doctrine has been explained by the Supreme Court. 2024, no?
So you first show me the plaintiff pleading, how the judgment has dealt with it. This is the same thing.
No, this is not a 5.8 situation. I am, my lord, placing this judgment. My lord, this is, my lord, 5.8 was also considered. This position was explained. But here, my lord, the relevant paragraph is with regard to group of company doctrine. Lordship permits me to place these paragraphs. I think, my lord, the query of the court will be answered.
Paragraph?
87 onwards, I'll place few paragraphs, my lord.
Yes.
Kindly first come to para 87, where this, my lord.
Wait.
This should be, my lord, page 80 of the, my lord, judgment which I handed up. Lordship will find the page numbers left hand side top corner.
Wait.
Yes.
87. It is 62.
Yes. 60.
Page 62.
The PDF page is not matching with it. Page 62, yes. May I place, my lord?
Yes.
The phenomenon of group companies is the modern reality of economic life and business organization. Group companies are a set of separate firms linked together in formal or informal structures under the control of a parent company. The group companies can be defined in the Indian context as an agglomeration of privately held and publicly traded firms operating in different lines of business, each of which is incorporated as a separate legal entity, but which are collectively under the entrepreneurial, financial, and strategic control of a common authority, typically a family, and are linked by trust-based relationships forged around a similar persona, ethnicity, or community. A group company involving the parent and subsidiary companies is created for myriad purposes, such as limiting the liability of the parent corporation, facilitating international trade, entering into business ventures with investors, establishing domestic corporate residence, and avoiding tax liability.
These are the issues.
Next slide. 93. My lord, the Solomon's case was, my lord, discussed in paragraph 88. My lord, I am not troubling your lordship with Solomon and Solomon or Vodafone, which was considered. Lordship kindly comes to paragraph 93.
83.
At page
83.
83, at page 64.
Paragraph
93.
Yesterday,
And I'll show also the facts, my lord, of this.
Yesterday, you got your order on server?
Yes. Lordship is talking about that injunction on construction, status quo to be maintained. Yes. Not bothering. Moreover, since the companies in a group have separate legal personality, the presence of common shareholders or directors cannot lead to the conclusion that the subsidiary company will be bound by the acts of a holding company.
Correct.
Statements or representations made by promoters or directors in their personal capacity would not bind a company. Similarly, mere fact that two companies have common shareholders or common board of directors will not constitute a sufficient ground to conclude that they are a single economic entity. The single economic entity or single economic unit theory imposes general enterprise liability on the corporate group. In DHN Food, Lord Denning held that a group of 3 companies should be treated as a single economic entity on the basis of 2 factors. First, the parent company owned all the shares of the subsidiary companies to the extent that it controlled every movement of the given subsidiary. And second, all 3 companies in the group virtually acted as partners and could not be treated separately. I will show, my lord, from this fact, my lord, from our facts, that not only this commonality was there, my lord, in the agreement itself, this plaintiff company is being considered as the affiliate of Flint, Netherlands. And whatever he does is for Flint, Netherlands. Officers are also common, my lord. Shareholders are also common. I'll show that also. Now, my lord, after this, kindly come to paragraph 96.
Company, closely held company.
Kind of.
Closely held company. What new theory? The theory is old. If you go by the principles of lifting of corporate veil, right? If you go by the theory of fraudulent preference, so theories are old.
But maybe in the light of, my lord, the provisions of the Arbitration and Conciliation Act explained in a better way, my lord. Well, kindly permits me to place now from para 96. This is particularly with regard to arbitration agreement.
1 second.
the conclusion here.
Conclusion to last 123, 127, 130.
Para 5 section reference clearly.
Yes.
96, my lord. An arbitration agreement encapsulates the commercial understanding of business entities as regards to the mode and manner of settlement of disputes that may arise between them in respect of their legal relationship. In most situations, the language of the contract is only suggestive of the intention of the signatories to such contract and not the non-signatories. This is, my lord, the first impression, my lord, given in this paragraph. I'll just read it once again. In most situations, the language of the contract is only suggestive of the intention of the signatories to such contract and not of the non-signatories. However, there may arise situations where a person or entity may not sign an arbitration agreement, yet give the appearance of being a veritable party to such arbitration agreement due to their legal relationship with the signatory party and the involvement in the performance of the underlying contract. Especially in cases involving complex transactions, involving multi-parties and contracts, a non-signatory may be substantially involved in the negotiation or performance of the contractual obligations without formally consenting to be bound by the ensuing burdens, including arbitration. So, my lord, this concept is recognized that there can be a non-signatory party to a, my lord, contract who is more interested in the contract than the signatory to the contract, and the signatory acts as per the interest or as per the diktat of the, my lord, non-signatory. Now, my lord, kindly comes to paragraph 123, 123 at page 76 of that report, my lord.
Second half.
My lord has got that 123. May I place it, my lord? The participation of the non-signatory in the performance of the underlying contract is the most important factor to be considered by the courts and tribunals. The conduct of the non-signatory parties is an indicator of the intention of the non-signatory to be bound by the arbitration agreement. The intention of the parties to be bound by an arbitration agreement can be gauged from the circumstances that surround the participation of the non-signatory party in the negotiation, performance, and termination of the underlying contract containing such agreement. I will show the facts, my lord. A 5-8 situation was envisaged here. The Unidroit Principle of International Commercial Contract 2016 provides that the subjective intention of the parties could be ascertained by having regard to the following circumstances: preliminary negotiations between the parties, practices which the parties have established between themselves, conduct of the parties subsequent to the conclusion of the contract, nature and purpose of the contract, the meaning commonly given to the terms and expressions in the trade concerned, and usages. My lord, it's now very wide.
27.
Then, my lord, kindly comes to paragraph 127. What is the threshold standard? In Cox and Kings, Justice so-and-so observed that Reckitt-Beckinsale fixed a higher threshold of evidence for the application of group of companies doctrine as compared to earlier decisions of this court. This court's approach in Reckitt is indicative of the fact that the mere presence of group of companies is not the sole or determinative factor to bind a non-signatory to an arbitration agreement. Rather, courts or tribunals should closely evaluate the overall conduct and involvement of the non-signatory party in the performance of the contract. The nature or standard of involvement of the non-signatory in the performance of the contract should be such that the non-signatory has actively assumed obligations or performance upon itself under the contract. In other words, the test is to determine whether the non-signatory has a positive, direct, and substantial involvement in the negotiation, performance, or termination of the contract. I'll show all, my lord. Mere incidental involvement in the negotiation or performance of the contract is not sufficient to infer the consent of the non-signatory to be bound by the underlying contract or its arbitration agreement. The burden is on the party seeking joinder of the non-signatory to the arbitration agreement to prove a conscious and deliberate conduct of involvement of the non-signatory based on objective evidence. And while it kindly comes to 132. Paragraph 132. We are of the opinion that there is a need to seek a balance between the consensual nature of arbitration and the modern commercial reality where a non-signatory becomes implicated in a commercial transaction in a number of different ways. Such a balance can be adequately achieved if the factors laid down under Discovery Enterprises are applied holistically. For instance, involvement of the non-signatory in the performance of the underlying contract in a manner that suggests that it intended to be bound by the contract containing the arbitration agreement is an important aspect. Kindly marks this, my lord, sentence in the judgment, because according to me, this is what has exactly happened in our case.
Read on. For
Other factors,
for
instance, the involvement of the non-signatory in the performance of the underlying contract in a manner that suggests that it intended to be bound by the contract containing the arbitration agreement is an important aspect. Other factors, such as the composite nature of the transaction and commonality of the subject matter, would suggest that the claims against the non-signatory were strongly interlinked with the subject matter of the tribunal's jurisdiction. Looking at the factors holistically, it could be inferred that the non-signatories, by virtue of their relationship with the signatory parties and active involvement in the performance of commercial obligations, which are intricately linked to the subject matter, are not actually strangers to the dispute between the signatory parties. My lord, after this discussion, it has been summarized in the form of a conclusion. Now permits me to place the conclusion paragraph. But before I show that, let us just to answer my lord's query, what is, my lord, the factual, my lord, situation in which this judgment was rendered? Kindly comes to paragraph 2 paragraphs, paragraph 2 and paragraph 5. আমি আরো দুটো প্যারা দেখাবো।
Yes.
Paragraph 2. 5 judges of this court are called upon to determine the validity of the group of companies doctrine in the jurisprudence of Indian arbitration. Lordship has para 2. The doctrine provides that an arbitration agreement which is entered into by a company within a group of companies may bind non-signatory affiliates if the circumstances are such as to demonstrate the mutual intention of the parties to bind both signatories and non-signatories. This doctrine is called into question purportedly on the ground that it interferes with the established legal principles such as party autonomy, privity of contract, and separate legal personality. My lord, this was the, my lord, original, my lord, view of the courts interpreting section, my lord, 8. Challenge before this court is to figure out whether there can be a reconciliation between the group of companies doctrine and the well-settled legal principles of corporate law and contract law. 5.1. Then kindly comes to para 4.1a. Whether the phrase claiming through or under in section 8 and 11 could be interpreted to include the group of companies doctrine. This is precisely my argument, my lord, that plaintiff is claiming through Flint, Netherlands, and therefore the group of companies doctrine ought to be invoked in this case. 5.1. Then 5.1a. Whether the group of companies doctrine should be read into section 8 of the act.
Wait, 5.1a.
A, my lord, 5.1a, I'm sorry. Whether the group of companies doctrine should be read into section 8 of the act, or whether it can exist in Indian jurisprudence independent of any statutory provision. So this was, my lord, the question that was being answered by the, my lord, larger bench. Page 90. Now, my lord, 2 more paragraphs before I take your lordship to the conclusion. Paragraph 144, this should be at page 83. 83. 82 হবে বোধহয়, page 82. 82, it should be 82.
Yes.
The phrase claiming through or under has been used in sections 8 35 and 45 in their specific contexts. Section 8 contains a mandate that when an action is brought before a judicial authority which is the subject of an arbitration agreement, the dispute shall be referred to arbitration on an application made by a party or any person claiming through or under him. As mentioned above, the phrase claiming through or under was inserted in Section 8 to bring it in line with Section 45. Sections 8 and 45 are peremptory in nature, mandating the court to refer the parties to arbitration if there is a valid arbitration agreement. In A. Ayasami, it was held that Section 8 imposes an affirmative obligation on every judicial authority to hold down parties to the terms of the agreement entered into between them to refer the disputes to arbitration. Thus, the legislative intent behind Section 8 and 45 is to ensure that parties fulfill their mutual intention of settling disputes arising between or among them by way of arbitration.
Parties to the terms of the agreement entered into.
Yes. Now, I skip para 145. Kindly takes 146. Next page. Sections 8, 35 and 45 use the phrase parties or any person claiming through or under. The word or is used in Section 8 and 45 as a disjunctive particle to express an alternative or give a choice between parties or any person claiming through or under. Consequently, either the party, this is very important, consequently, either the party to an arbitration agreement or any person claiming through or under the party can make an application to the judicial authority to refer the dispute to arbitration. It is in the interest of respecting the intention of the parties and promoting commercial efficacy that the above provisions allow either the party or any person claiming through or under him to refer the disputes to arbitration. Now, my lord,
does the
conclusion.
plaintiff claim in the plaint?
No, plaintiff is avoiding. Plaintiff is avoiding. I am saying that the plaintiff's claim is not an independent claim. Plaintiff is actually claiming through the parent company, Flint Netherlands.
What is the basic principle for adjudication of a suit? The issue has to be framed. Now, issue has to be framed on the basis of what?
Pleadings.
Pleadings. Now, if there is, in absence of any pleading, no issue can be framed thereupon, correct? Unless an issue is framed, no adjudication will be there on that issue. Now, primarily, it is the statement in the plaint which is the basis of framing an issue, because plaintiff has to assert, defendant has to deny.
Plaint and written statement.
Sorry, that's right.
Yes,
Plaintiff has to assert, defendant in its written statement has to deny.
Yes.
Then gives rise to an issue. Right? Now, if the plaintiff does not assert anything, whatever you are saying, there will be no issue on that point. Then the adjudication, if he succeeds, if the plaintiff succeeds in his plaint, on his plaint, he has to succeed on his plaint and plaint alone.
Mala, taking a cue from your lordship's example, there can be two situations. Let us envisage, Mala, two situations. One, where there is a written statement. In this suit, there is a written statement where I refer to that agreement. Then this issue could have been raised. Here, there is no written statement. I have taken out an application simpliciter under sections 5 and 8, contending that the plaintiff cannot claim right independently, but from an agreement which is binding on the plaintiff, which contains an arbitration clause, and plaintiff cannot avoid that mechanism. So in a 5-8 situation,
this is your factual defense?
No, in a 5-8 situation, lordship has to, my lord, see the averments in the 5-8 application to determine whether there is, my lord, an arbitration agreement which can cover the subject matter of the dispute.
But yes, of course I will. But this defense you are taking, it is a defense for your client, the defendant's defense?
My lord, this is not a defense. This is only to, my lord, point out to the judicial authority that please don't exercise your jurisdiction. There is an alternative mechanism that the parties have agreed to. So I am not inviting the court to adjudicate anything on merit. If the court feels that yes, parties had agreed to an alternative dispute resolution clause, to an alternative mechanism for resolution of their disputes, the judicial authority is only to refer the matter. That is why that expression affirmative obligation on the judicial authority, which I read. So, my lord, here lordship has to see. Lordship may not accept my contention in the fact, in this fact, but what the point I am trying to make is that in a 5-8 situation, lordship, it may not be that in the plain there would be a reference to a dispute which will be straightway, my lord, covered by an arbitration agreement between the plaintiff and the defendant. There may be situations where the plaintiff has framed his cause of action in a manner to avoid an arbitration mechanism, which may not be beneficial for him. Maybe it's costly. So it's not beneficial for him. But he wants to recover.
Devoid of those facts, those case being made out in the plaint, if the plaintiff does not succeed to his claim, he will not succeed with his plaint.
No quarrel with that, my lord. But since your lordship is hearing a 5-8, lordship will not restrict the enquiry to the plaint only. It is the language is, may I read the language of the, my lord, statute once, my lord, before I come back to the conclusion of the, my lord, Cox and King's judgment. A judicial...
Let's see.
Yes, my lord.
Section 5.
8.
It has to be filed before filing WS. Filed before filing WS. This is
a judicial...
WS.
Yes.
8.1. A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement. This is the only, my lord, limited scope of inquiry. In a matter which is the subject of an arbitration agreement, shall, if a party to the arbitration agreement or any person claiming through or under him so applies not later than the date of submitting his first statement on the substance of the dispute, then notwithstanding any judgment, decree or order of the court,
if a party to arbitration agreement or any person claiming through or under him so applies.
I am saying
the applicant.
I am saying
which is the applicant under 8. Which means the applicant under 8. You are not the...
I am the applicant under 8.
Right. But you are not related to either with the plaintiff or its holding company.
No, my contention is plaintiff is claiming his right through the arbitration agreement which is contained in the parent agreement.
No, but that is not the language, sir. Subject to correction. Read again.
A judicial
slowly.
authority,
Let's read slowly.
A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement.
Stop.
This is the first condition.
Stop. So this is the plaintiff. Up to this plaintiff.
Yes.
Up to this plaintiff.
Plaintiff.
Then read.
Shall.
No. If a party.
Yes.
The arbitration agreement.
Subject of an arbitration agreement shall, if a party to the arbitration agreement.
Then comes the next.
Or any person claiming through or under him so applies not late.
When you start reading from the expression if a party to the arbitration agreement.
I get what your lordship is indicating.
It denotes the defendant.
That the applicant in section 5.8 has to claim through or under. This is what lordship is.
If a party to the arbitration agreement or any person claiming through or under him. So this means the applicant under 8. This means the applicant under 8, not the plaintiff. That is what I was telling you so long. So long I was trying to tell you that. This means the applicant under 8.
This might have answered the conclusion. Conduct definition parties
This means the applicant underage.
Right.
So if
And I will proceed on that
Mr.
premise.
Rajarshi Datta files a suit against Mr. Chaudhary, being the defendant. Who is the defendant? Mr. Chaudhary files an application under 8 with a plea. Either he is directly a party to an arbitration agreement with you. Between Rajarshi Datta and Mr. Chaudhary, there is an arbitration agreement. Option 1. Situation 1. Situation 2. Mr. Chaudhary claims a right from a person or through a person or under a person which is being affected by filing the suit, may be affected by filing the suit, who is a party to the arbitration agreement with Mr. Rajarshi Datta.
Then,
so the applicant either itself has to
so
be
there
a
is
party.
there is no change in the entity of the plaintiff. The agreement can be either with the plaintiff and the defendant,
Plaintiff is
or
constant.
plaintiff is constant, plaintiff and the defendant, and
Plaintiff and the party to the arbitration agreement, who is a defendant,
or someone defendant is claiming through. Defendant is claiming rights through someone.
So the applicant of 8 has to have this character.
This is one of the this is the provision in section 8 where a person who is directly a party to an agreement or a person who is claiming rights through somebody who is a party to the agreement can apply. Now, my lord, kindly apropos this, see the conclusion of Cox and Kings, because this is not restricted to the person applying.
Group of companies applies to a party, not the person.
The group of companies doctrine, Cox and Kings, my lord, the Supreme Court has held, it is applicable to party to an agreement. And party to an agreement here can either mean, my lord, the plaintiff or the defendant.
The applicant or the recipient.
The applicant or, my lord, the plaintiff, the person who
No,
is
yeah,
instituted there.
তা হবে না।
My lord, kindly cease.
Kindly,
Section থেকে override
I am not saying section has been overridden, but interpretation of the, my lord, expression party in Cox and Kings means that even, my lord, if there is somebody who is instituting an action or bringing an action to court, if he is claiming through someone and there is an arbitration agreement, that can also be, my lord, referred to reference. Kindly takes note of the conclusion paragraph now.
I will. You will place it.
Section 8 I have understood. Lordship is absolutely correct. That applicant or applicant claiming through somebody who has an arbitration
Applicant
agreement.
under 8. Applicant under 8, not the plaintiff.
My lord, understood and accepted. Kindly now, my lord, takes, my lord, conclusion part of, my lord, Cox and Kings. My lord, paragraph 170. In view of the discussion above, we arrive at the following.
One second.
This is at page 90.
Slowly. Yes.
My lord, before I place the conclusion part, kindly take section 21H once. The definition of party.
Yes. Absolutely. What I have said, the same
party
thing.
To an arbitration agreement? No. Arbitration agreement.
Or a party claiming right under a party to the arbitration agreement. That's the language of the 8.
Yes.
So the plaintiff stands closed the moment he has filed the suit. Right? He is no more a party within the meaning of section 8. Now comes the defendant. Either the defendant has to be directly a party to the arbitration agreement, or he claims a right under a party to the arbitration agreement as against the plaintiff.
My lord, if this is subject to being corrected, if this is, my lord, correct, then my lord, a situation like the present one, where a plaintiff is trying to avoid an arbitration agreement, plaintiff knows there is an arbitration agreement between the defendant whom he has sued and his holding company.
The easy answer is there. I have indicated that.
Party.
The moment plaintiff has avoided the agreement, right? So he cannot rely upon that agreement in the suit while proving his case any further. Think of a situation.
That's for trial lordship is indicating.
Yes.
At merit he may not succeed. That is what.
But remains.
No, my lord, independent of that agreement, he may still succeed. I am not, my lord, trying to visualize today whether he will succeed or not. I am on a different point altogether, that this expression party has to mean both the plaintiff as well as the defendant.
Show me.
The
Let's
concept
come
of
to the conclusion.
Yes. 170.1. The definition of parties under section 21H, read with section 7 of the Arbitration Act, includes both signatory as well as non-signatory.
Agreed.
This has got nothing to do with 8. This is 21H
This
and
has
7.
This has got to do with it.
I'll come. 8 is also explained. I'll come.
Because
Permits me to, my lord, just complete 170, the subparagraph.
Yes, you do in your own way. Sorry.
No, my lord. Absolutely not. 170.2. Conduct of the non-signatory parties could be an indicator of their consent to be bound by the arbitration agreement. Then 3. Requirement of a written arbitration agreement under section 7 does not exclude the possibility of binding non-signatory parties. Then 170.4. Under the Arbitration Act, the concept of a party is distinct and different from the concept of persons claiming through or under a party to the arbitration agreement. The underlying basis for the application of the group of companies doctrine rests on maintaining the corporate separateness of the group company while determining the common intention of the parties to bind the non-signatory party to the arbitration agreement. I'm skipping 6, then 7. Group of companies doctrine has an independent existence as a principle of law which stems from a harmonious reading of section 21H along with section 7 of the Arbitration Act. Now I pause here for a moment. Coming back to the definition, coming back to the provision in section 8, that right to apply is recognized for two kinds of parties. This section 8, it is only a recognition as to who can apply, because the application has to be made by a defendant. A defendant can either have an arbitration agreement directly with the plaintiff. A defendant may not have a direct arbitration agreement, but he can say that there is an arbitration.
Claim some right.
Yes.
Under a party to the arbitration.
Now I say there is an arbitration agreement with the plaintiff. And I am inviting your lordship to invoke the group of companies doctrine.
No, not plaintiff. Plaintiff is not a party to the arbitration agreement.
No, I am saying because
I am saying first correct me factually.
No, lordship is correct. There is no black and white agreement between the plaintiff and the defendant. But why am I inviting your lordship to
Rather, I will say that there is no black and white agreement arbitration agreement executed by the plaintiff where the transaction pleaded in the plaint.
Very well. Correct. With the defendant. Now, right to apply, defendant could have applied if there was a written agreement between the plaintiff and the defendant. Defendant could otherwise have applied if defendant was claiming a right through somebody who had a direct agreement with the plaintiff. So section 8, that interpretation which we my lord discussed just now, that is, my lord, for the purpose of applying to the court. Now I am saying, please invoke the group of companies doctrine recognized by Cox and Kings, que the plaintiff. This is not when I can apply, not que the defendant. Please invoke the group of doctrine, que the plaintiff, and then see whether there is an arbitration agreement which binds the plaintiff or not. Lordship may hold that because there is no black and white agreement between me and plaintiff.
But Mr. Dotto, how can I travel beyond the plaint? It's not pleaded at all.
That is what, my lord, I am trying to persuade your lordship in view of what has been laid down in Cox.
What you are saying that in view of what the law laid down in Cox and Kings, I have to read something more than the plaint.
No.
Is it possible?
No, I am saying, please consider the definition of party in 21H. Please consider section 7 and the law as summarized in the conclusion at para 170 to mean that a party, a group of, a party or a person claiming under, as in the plaintiff here claiming under somebody, this can be looked into at a 5-8 stage. This was also a 5-8 situation.
But if the case is not made out in the plaint,
then also Lordship can. That case need not be made out in the plaint. That case will never possibly be made out in the plaint. If I want to avoid the agreement, why should I make out that case in the plaint?
Precisely. So you have to succeed the case as you have made out. If you fail, you will fail.
Lordship is then, my lord, proceeding on the strict principles of a demurrer application. That you have to see what is there in the plaint unless you can show he is claiming right under.
No. Plaint, reading of the plaint is the primary consideration. May what come. That's the
My lord,
basic
only
law.
to see the subject.
That's the elementary.
My lord, plaint is to be seen only to see whether the subject matter of the suit can be carried to the reference. My lord, if Lordship otherwise does not, my lord, travel beyond this, my lord, plaint while deciding a 5-8 application, then, my lord, possibly a defendant cannot establish that a person is claiming right through somebody who may have an arbitration agreement with the defendant. Application that can be made under 8, there is no dispute that there are two entities who can make, one directly associated with the plaintiff where there is an agreement, or one who is claiming under somebody who has a direct agreement with the plaintiff. But party, the expression party would include both plaintiff and the defendant.
Kindly let us read the section.
21H. Kindly
No, 8.
A judicial authority.
8 is an independent provision. Arbitration Act is a self-contained code.
Right.
So, read. A judicial authority before which an action is brought in a matter
which is the subject of an arbitration agreement.
So, the plaintiff must first disclose that this is the subject matter, which is a subject matter under an arbitration agreement.
My lord, at the cost of being reprimanded, if I had been the, my lord, draftsman, I would never, my lord, indicate that in the plaint because my suit will fail then.
Then no.
My
suit will not fail. Your suit will fail had this been such an agreement, such an essential agreement, without which plaintiff cannot prove his claim. Can you plead that? Can you run the risk? Tell me. A draftsman who drafts the plaint, if this is an essential factor, can a plaintiff, forget about the draftsman, can a plaintiff ignore that document? Knowingly that I will fail ultimately, I cannot.
Actually not, but in a case of price, my lord, unpaid price for goods sold and delivered, invoices, purchase orders, and my lord, bank statements are good enough.
Matter ends. If those are good enough, and hypothetically, if the admission is in your balance sheet, let's say that towards Mr. Chaudhary you owe 500 rupee, sufficient for order 12 rule 6 or order 13A amended, sufficient.
My lord, my submission would be, my lord, apropos section 8, that if I can show from the plaint that the subject matter of the suit is covered by an arbitration agreement.
It's a matter of trial. And if you can show that in cross-examination, and if that stands, which is not the case of the plaintiff, plaint fails. Simply plaint fails. Why should we travel up to that stage? We will read the plaint. We will see section 8. Of course, I will read this judgment. I'll take this judgment. In my, so far now at least, subject to hearing you, that matter ends. Not required to travel more than that.
May I come back another day, my lord?
আবার
No, I want to, my lord.
শেষ করো
No, I want to show your lordship the documents also.
not required show it from your affidavit and section 8 application.
Yes, from that.
Yes,
From that.
show it.
There's a chart, my lord.
You're welcome.
Kindly takes my reply.
Yes. Now reply now.
রেভিনিউ একটা রেফার করেছিল চিঠিতে ওরা বলেছিল
First you show me your section 8 application pleading.
In my application, the pleading, yes.
Averments from your application.
Yes.
আগে পিটিশনটা দাও এই তো পিটিশন
Kindly comes to paragraph 5. This will be GA4.
whatever.
Paragraph 5. Plaintiff has failed to disclose before this honorable court that the transactions and/or invoices on which reliefs are based are governed by a distributorship agreement that mandates dispute resolution through international arbitration. Despite the existence of this arbitration clause, plaintiff has proceeded to file the present suit. Material facts deliberately suppressed by the plaintiff are as follows.
Not required. acha.
Flint Group is a global establishment in the supply of products for the printing and packaging industries referred to as Flint Group. It has its headquarters at so-and-so, New Jersey, USA. It operates more than 125 centers worldwide, including in India, where the plaintiff in the present suit operates as its selling affiliate. I'll show the document separately. Let me just place the averments. Flint Group, India Private Limited, the plaintiff, is a selling affiliate owned and controlled by Flint Group, operating within its global framework. As a selling affiliate,
Mr. Dotto,
these facts.
Are these not triable?
These facts. Kindly seize the
Are
document.
these not? I admit these facts. Let me admit. Are these not triable?
My lord, if lordship admits, then I am, my lord, through that because there is an arbitration agreement in.
Why should I admit? At your 8th stage, these are all tribal issues. You have to prove when the witness of the plaintiff will be in dock.
My lord, affidavits were invited. He was, my lord, given an
By
opportunity.
way of cross-examination, you have to say that your plaint case fails. These are all those materials.
But these are, my lord, documents which would otherwise establish.
Correct.
Plaintiff.
Correct. But these are to be put in as cross-examination when he will be on dock.
I can't hear. No written statement file.
Absolutely. That's more the reason you are fighting so hard. Understood. No issues in accepting that contention and no issues. But these cannot be. Section 8. Will I hold a mini trial by seeing every document?
To see whether, my lord, there is an arbitration
You have
agreement,
missed the
lordship can.
I will have to see on a plain eye.
Otherwise, my lord, this group of companies doctrine, it was not required. It would have been restricted to party.
You place the judgment. Then I will read it again on my own and subject to hearing.
His case in the opposition, when I rely upon that agreement, distributorship agreement, his only case is that this document was not signed. He does not say that there was no such document.
Moment he says this document was not signed
so
by
in reply, I showed the communication which says that
these are all tribal then. The moment these sentences are coming, these are all tribal. These are all tribal, not a case of 8.
Then no point showing these documents.
You are welcome.
No, I wanted to show these documents to.
You show this. You take your own way and own time. I don't mind for that.
Kindly come to page 16, my lord, the document itself.
1/6.
I'll not waste time by reading the averments. 1/6 of the reply, affidavit in reply.
Page?
Page 16.
Yes.
At the foot of the page, Lordship will find an email of 20th April 2020. From Vera Abramova. Lordship has found that.
Yes.
Just above that, there is a heading compliance issue, dealers without contract.
Yes.
The subject of the email is compliance issue, dealers without contract. I hope you are well. This is addressed to the Upal Roy is basically the company plaintiff's my lord representative of India, the plaintiff's representative. Revising our compliance archive, we located 5 packaging dealers, agents and distributors in APAC region, that's Asia Pacific, that were approved before October 2019. Contracts were sent to the responsible relationship manager to procure a signature by the dealer. Unfortunately, we received no contracts for these dealers until today. This poses a serious danger to our compliance situation and is not audit proof. We ask you to kindly review the attached list. If we conduct business with listed dealers, provide us with the contract that was signed by the dealer by so and so. If we don't conduct business with the listed dealers any longer, let us know. We will have all corresponding dealer accounts blocked on SAP. Then, my lord, going up, same page at page 16, the response on 21st of April. Hello, Vera, please find response with reference to Indian distributors agents. Number 1 is SAS, my lord,
The
defendant. INC process for SAS had got completed sometime in September 2019, but I don't find any email sharing the agreement with them for getting it signed. Last mail I have received on this subject from so-and-so is appended below. Please help me with the agreement so that the same can be executed and so that the same can be closed. Now, my lord, kindly comes to page 15. It's a trail mail, so my lord, I go from the foot of that page.
This communication between Flint India and Flint Netherlands.
My lord, this is from
Whereas Flint Netherlands, Sachin
the
Kumar,
group
Flint-
legal head of Flint, my lord, Netherlands, to my lord, page 6, 15, 15, the last email.
This is the communication.
Communications. Now, I want
Intra-party communication. Not even intra-party, whatever.
intra-party as well as, my lord, the, yes. I looked up in your files, the contract for SAS was sent on September 27 to Amor Sen. If it is okay, we can send out the contract to be signed electronically through DocuSign. We would just need the names and emails of the signatories on the part of SAS. Then at the middle of the page, did you get this agreement signed from SAS? Do you have the signed copy with you? If not, will SAS be able to sign this using DocuSign? He just needs internet connection to sign this. Then kindly comes to 14, my lord.
So up till now, it was not sure that the agreement was signed or not.
Netherlands, Flint, Netherlands was inquiring from Flint,
That's
India.
precisely. So the agreement is whether signed or not, that
Now-
is also not sure.
But no, now I will show, my lord, from the
Ah.
last
No,
correspondence.
no, I said that up
yes,
to this.
yes.
Page 27.
Page 14, Lordship sees this is a mail. At the middle of the page, Lordship will see the name Amor Sen. On 21st of April 2020, there is a mail addressed to Sujoy Lodha. 21st April 2020 at 23:15 hours. Middle of that page. Dear sir, your agreement copy is not yet signed. Now, if you have internet connection, then using DocuSign, you can complete the same. Please confirm, it's most important. Amor Sen, Deputy General Manager, Sales, Packaging Inks and Resins. Then, my lord, kindly sees Flint Group. He is, my lord, Amor Sen is of the plaintiff. He is, my lord, using a domain name of, my lord, Flint Group, and he is, my lord, signing or issuing emails as if, my lord, he is a representative of the Flint Group. Now, to show that the document was ultimately signed, let me take your lordship through
Page 45.
page
45.
না যেখানে সাইন করলো yes kindly come to page 22 this is an email of 22nd April 2020 hello Vera please send me the agreement for signature through DocuSign to them proprietor Sujoy Lodha. It will be great if you please keep us informed once this is sent to him so that we can follow up to ensure that my lord,
22
page 22 just after the first mail at the top.
It will be great.
It will be great if you please keep us informed once this is sent to him. To him means to Sujoy Lodha, so that we can follow up to ensure that it gets signed. Now I show the signed document. Page 45.
Yes.
This is my, I want to show my lord my reply on 30th of May, again the foot of that page, from Sujoy Lodha, Lordship will find 30th of May 2020 to Amor Sen and Sandeep Singh. Forward agreement, we refer to our email dated 15th May and your subsequent reply of 19th May. Due to our past relationship with Flint, we are sending you the agreement with signature, but we are still concerned on certain clauses in the agreement which are either irrelevant in the present state of business affairs between us or are legally inexecutable in its present form. So my client says that there we are sending the agreement with signature. Where is the signed document? Kindly takes agreementable. Agreement
is this not a process
29.
for holding a mini trial? All right, show me. Page.
Otherwise, my lord, I have no other document to establish there is an agreement. Apart from showing from my affidavit or my petition, there is nothing else on record to suggest that there is an agreement that I have with the plaintiff who is claiming under Flint, Netherlands. Agreement is 29, page 29.
29?
Yes, of the same reply.
All parties have signed.
Agreement between holding company of plaintiff.
Flint, Netherlands.
Holding company of plaintiff.
Parties are
and
my client SAS. Kindly comes to page 31.
Yes.
Clause Article 1.1. Subject to the terms and conditions of this distributor agreement, Flint, Netherlands grants to distributor a non-exclusive and non-assignable right to distribute the products listed in Schedule 1. This is being granted by Flint, Netherlands to distributor.
Who is the distributor? Your client.
Yes. That is SAS. Now, Lordship will find at the top there is a DocuSign entity or entry.
What is the nature of transaction claimed in the plaint?
Goods sold and delivered.
How? Plaintiff simple cases. Look here, I have supplied goods against an agreed price. A defendant accepted the goods. Defendant did not pay.
Correct.
This
That's
is
the simple case.
Simple case.
No reference of these agreements or these documents.
Suppose the plaintiff obtains goods. Suppose the plaintiff obtains the goods from a third party. That is a independent transaction between the third party who is the seller to the plaintiff or who is the supplier to the plaintiff.
Can be, yes.
Right. It has got nothing to do with the defendant, present defendant. Correct?
Unless Lordship accepts that yes, because one of the articles of this agreement describes what is a Flint selling affiliate, because we have said, kindly takes Article 3.1.
Page 143.
143 cannot.
3.1.
At page 32, Article 3.1, distributor shall buy the products in its own name and for its own account from the respective selling Flint affiliate.
Respective
selling Flint affiliate.
Selling affiliate to defined columns.
1.4.
1.4 selling affiliate.
1.4 अपनी affiliate से बात है. Controlling affiliate আছে. Hence there is a control by virtue of this agreement.
Affiliate is defined. Flint Netherlands is the parent company. A selling affiliate is defined and a controlling affiliate is defined.
Where?
At 1.4. Clause 1.4, page 31. Distributor shall have a non-exclusive right to distribute the products in the contractual territory. That is, Flint Netherlands may appoint other sales organizations, in particular commercial agents or distributors for the products in the contractual territory. In addition, Flint Netherlands or its affiliates
shall be
may conclude transactions in respect to the products directly with key customers. So this agreement recognizes that I rest it there then.
Then
one last communication I show and I rest it. Page 43.
Page
of reply, page 43.
43?
Yes. This is prior to my lord signing of the document. Again, an exchange of email from Flint's my lord, the plaintiff's officer and the defendant. And this is plaintiff stand. Email of 19th May 2020 at page 43. Dear Sujayji, please refer below from our CFO, which is repetition what we discussed earlier and today. All distributor agreements are being centrally signed by Flint through Flint Netherlands only. And all dealings will happen with India. This is the company policy with no option. Please note this is a dealership agreement. We are run by Flint.
One second. All distributor agreements
are being centrally signed by Flint through Flint Netherlands only.
And through Flint Netherlands only.
Yes.
So who is the signatory?
Flint Netherlands. Non-signatory claiming through the signatory. That's my case.
But communication is happening through
And
Flint
all
India.
dealings will happen with India. Please note this is a dealership agreement. We are run by Flint, which is a global footprint. So policy on appointing dealer to represent Flint, a global brand, financial dealing will be with India. But as policy and standard is global, this has come from our sales director. Hope the above is good enough to satisfy. So they also admit that it is Flint Netherlands who is, my lord, the signatory, and they are selling, or my lord, whatever goods they are supplying is under the Flint Netherlands banner. They have framed the suit in a manner to avoid that dispute resolution clause, which I was trying to, my lord, persuade your lordship that this group of companies doctrine should be understood in the concept of, in the backdrop of, my lord, the definition of party in 21H to bind the plaintiff also to the arbitration agreement.
Sign the tests of commonality of subject matter and composite transaction.
That is all, my lord.
No further? Sure? You are happy?
Of course. Not with the result, but of course with the, my lord.
How do you know the result?
But two things, if I may say, Malad, apart from what you're
Take the microphone.
two things, if I may say.
Pleasure to meet us. Still possibly go on.
No. I don't believe in that practice. Yes.
But apart from what has fallen from your lordship, that defense has been taken in my opposition. This is my principal point of objection.
First, you deal with the judgment.
Yes, my lord, as your lordship has pointed out, my lord,
Whatever I pointed out, forget it. You deal the judgment in your own way.
Lord, the group of companies doctrine will not be applicable here. Why? I'll tell my lord.
Why?
That's what the
Full name?
Shourojit Dasgupta.
Soumojit.
Shourojit Dasgupta.
Sourojit.
But what the defendant is saying, my lord, I have demurrer points which I'll address your lordship on a little later after I deal with the group of companies doctrine. But what the defendant is saying that there was a distributorship agreement with the holding company of the plaintiff. And under that distributorship agreement, the defendant sold certain goods to the plaintiff. That is the long and short of what the defendant is saying. In my opposition, I had said that the written document, the agreement is unsigned and undated, and it is in any event not with the plaintiff, so I am not bound. And the plaintiff also does not say so. Group of companies doctrine say that if I am claiming, or that is the defendant is claiming, through anyone or by himself, and that is the subject matter of an arbitration agreement, then disputes can be referred.
Take me to the judgment.
But certain paragraphs have been placed. But if I may take your lordship to, there's one paragraph which my learned senior friend had also placed, but which was in line with what your lordship had observed. That it is only the party applying.
Show me.
Yes,
where whichever paragraph you want
I
to
shall
cite,
show.
you cite.
I noted it down.
Because your principal endeavor would be to come out of this judgment.
Yes.
Because this judgment is the sheet anchor for Mr. Dotto.
Yes.
So you demonstrate how will you get out of it.
Yes. But
what I am thinking, forget.
No, but I understand. But first is why I have a demurrer point which I may come to, if your lordship so pleases, I can point those two points I have taken in demurrer, because this application is not maintainable. First is section 8 says that application for reference to arbitration in a suit can be taken out on or before the date of filing the first statement to the pleadings in the plaint. If I may place section 8.
Filed.
Yes. And it has, this application has also not been filed prior to the first date of filing any objection to my claim. Kindly, if I may place section 8 once. Section 8, subsection 1. A judicial authority before which an action is brought in a matter which is the subject of an arbitration agreement shall, if a party to the arbitration agreement or any person claiming through or under him, so applies not later than the date of submitting his first statement on the substance of the dispute. So it has to be filed not later than the date of submitting his first statement on the substance of the dispute. Now, the first statement on the substance of the dispute would either be the written statement.
It's a written statement.
Or even an affidavit in opposition to my interim applications. But there are judgments which hold that first statement.
That's right,
is also
but
an
ultimately it is the written statement.
It is the written statement. Now, my lord, if I may place one, I've prepared one list of dates where, my lord.
Very well, first you make your submissions on this judgment.
On Coxing things, yes. Yes, my lord, paragraph 146.
Yes.
Paragraph 146, if I may please. Sections 8, 35 and 45 use the phrase parties or any person claiming through or under. The word or is used in sections 8 and 45 as a disjunctive particle to express an alternative or give a choice between parties or any person claiming through or under. Consequently, either the party to an arbitration agreement or any person claiming through or under that party can make an application to the judicial authority to refer the dispute to arbitration. It is in the interest of respecting the intention of the parties and promoting commercial efficacy that the above provision allow either the party or any person claiming through or under him to refer the disputes to arbitration. So a party who wants reference to arbitration has to apply.
Applicant of section 8.
Applicant of section 8, either that or any person claiming through or under him.
Applicant of section 8 must be either a party directly to the arbitration agreement
or any person,
a party who is claiming some right under an arbitration agreement, which is the subject matter of the suit.
Yes.
So what he is saying, according to you, that the plaintiff cannot be construed within the expression party here.
It could have been that the plaintiff is a party to an arbitration agreement. The defendant is not. Some other person claiming through the defendant, because that is what it says. Either the party or any person claiming through or under him.
That's right. So
that party could have come.
Arbitration agreement should be the subject matter of the suit.
Yes.
First.
Yes.
Then the defendant either has to be a party to that arbitration agreement or he claims a right through another party who is a party to that arbitration.
Yes. And that is also what this judgment says, paragraph 146. So on that note, this application fails. Secondly,
due to locus.
Secondly, section 8 says a judicial authority before which an action is brought is a matter which is the subject of an arbitration agreement. Now, the arbitration agreement which my learned senior friend has shown your lordship would have seen, lordship has seen one clause. There are many other clauses where it gives the power to the selling affiliate, which according to the defendant is the plaintiff here, the selling affiliate, to initiate actions against the distributor, and that will not be covered by this distributorship agreement. So my action, even assuming that my right to sue the defendant or dealing with the defendant comes from
Show
the
me that.
Yes. Lordship takes the application. Application page.
I have the application. Yes. No, reply or application.
The application also has the same agreement. 142, Lordship has noted clause 1.4. I'm not placing it again. 1.4 says distributor shall have a non-exclusive right to distribute the products in the contractual territory. That is, Flint, Netherlands may appoint other sales organizations, etc. for the products. In addition, Flint, Netherlands or its affiliates.
In addition,
Flint, Netherlands or its affiliates, as defined below, then Flint, Netherlands and its affiliates, hereinafter referred to as Flint, may conclude transactions in respect of the products directly with key customers or customers who belong to an internationally operating group within the contractual territory without recourse to distributor services. Flint shall inform distributor without undue delay if a customer is a direct customer, unless otherwise agreed. Parties and a distributor shall not be entitled to commission, etc., etc. So even without the distributor, which is the defendant here, I have an independent right to enter into further contracts with other persons. Now, my lord, kindly takes straight away to page 147. Before 147, there are nothing which is there in the agreement which governs the terms and conditions of the dealings between the parties to the suit. Then comes Article 7 at page 147, 7.5. May I place the entire article, 7.1. The products shall be sold to distributor on the basis of the orders placed by the distributor. I'm so sorry. The products shall be sold to distributor on the basis of the orders placed by distributor and Flint selling affiliates order confirmations. So that is an independent transaction that distributor places order and I sell the products. Unless otherwise provided for in this agreement, the current prevailing terms and conditions of the sale agreed between selling affiliate and the distributor, as well as the general terms and conditions of the sale of the Flint selling affiliate as modified shall apply to the purchase agreements concluded under this agreement. Then straight away comes to clause 7.5. Should distributor's financial situation threatened to deteriorate, or should distributor be in default of the payment obligation, Flint selling affiliate, which is the plaintiff, may at its own discretion, request from distributor, that is one, sufficient guarantee before execution of an order, second, the change of payment terms to cash in advance payments, and Flint selling affiliate may suspend deliveries until outstanding due payments have been made in full. Any further rights of Flint selling affiliate shall not be affected hereby. So whatever rights have been given to Flint selling affiliate as against the distributor, to the plaintiff here as against the defendant, let us take the defendant as the distributor, plaintiff against the defendant is not covered by this agreement. And this agreement imposes a right on the plaintiff that you may do whatever you want. These are your rights. So it is not that I am suing on behalf of Flint Netherlands. It is my claim. If the defendant pays, the defendant will have to pay me, not my holding company. Holding company will not have any right here. Right as against the distributor. So the subject matter of the suit, as has been pointed out, purchase order placed, goods sold, invoices raised, not paid.
Invoices raised by the plaintiff independently.
Plaintiff independently, without reference to the Flint Netherlands. Goods money not paid. Thereafter, there are repeated admissions, balance confirmations, even pre-suit, post-suit, for which I have taken out applications. But that is not the subject matter of this application. I will not take your lordship through that. So I have a right to sue the plaintiff has a right to sue the defendant, and that does not come under this distributorship agreement that has been harped on. So in any event, that these averments or these issues do not fall within the domain of Section 8. Subject matter of arbitration agreement has to be the subject matter of suit. There are various other obligations which are mentioned in this agreement. This agreement is essentially how the distributor should function. Distributor should not sell fake products. Distributor should not receive any commission for selling the products. Distributor shall not do this and that, anything illegal. These are the terms that the distributor should abide by. That is all that it says. It does not say that the distributor has to pay this amount. This is the admitted rate. And this is within what time the goods have to be, the orders have to be placed, the goods have to be sold. All those things are not subject matter of this agreement. Those are the terms and conditions of the purchase orders and my invoices. And that is why my suit could not have included this agreement at all, my plaint. My plaintiff may have interacted with the defendant during the process of execution of the agreement. The emails show that. I take it that yes, the plaintiff's employees had interacted with the defendant as also with the Flint Netherlands. But does it mean that Flint Netherlands has a privity of contract with the defendant, or the defendant has a direct privity of contract with Flint Netherlands insofar as his payment obligations are concerned? That, in my respectful submission, is not
very well. Tomorrow you come and you deal with the judgment.
I shall.
In your own way.
I shall.
Right?
Two more points I'll raise so that Mr. Datto can also respond in reply. One is date of filing of the first statement of defense. That has not happened in this case. Second is this application itself. This is a technical point. I would also own that. This application is not maintainable because one of the parties to the agreement to the distributorship agreement is a foreign entity. 2(1)(j) of the Arbitration Act, it is an international commercial arbitration. So section 45 could have been filed. This is section 8. So even on that note, this application is not maintainable. Thirdly, that it is mandatory when it has been settled by the courts that it is mandatory to produce the true copy of the arbitration agreement with the section 8 application. I'll cite one judgment, and this has not happened in this case. This is not a true copy which has come forward with the application. These are 3 demurrer points, but on the meat of the matter, on Cox and Kings, I'll address your lordship tomorrow.
You tell me those 3 points.
But first is
Answer.
absolutely.
Yes.
First is this application has not been filed not later than the date of submitting his first statement on the substance of the dispute. That is borrowing the language of the statute.
Application filed after date of
after the date of submitting his first statement on the substance of the dispute.
Hey, it was in রিফিলটা দেখে চেঞ্জ করে দিন application filed after the
date of submitting his first statement
filing first statement
on the substance of the dispute. But I'm harping on the word date of submitting his first statement.
Then
second is this application not maintainable. One party is a foreign party, ought to have.
Which is the foreign party?
The party to the arbitration agreement, Flint, Netherlands.
He is not a party to the suit.
He's not a party to the suit.
No.
So what on the arbitration agreement itself, if a party wants to apply,
party to the suit.
He's not a. That is my first defense.
If he is not a party to the suit, it is a suit filed against an Indian party.
Yes.
Then 8 applicable.
8 is not applicable because that foreign party is not party to the suit. That is one. And since an argument has been made,
he is saying that this is the agreement which should govern, containing an arbitration clause.
Yes.
So refer the suit
Yes.
before arbitration.
Yes.
Right.
Yes.
45 what says? 45 says what?
Reference of the parties to arbitration in an international commercial arbitration.
When?
Where one of the parties to the
that
arbitration.
agreement.
Yes. So this agreement which he relies
He
on.
is not saying that. He is saying under this agreement, plaintiff is also bound.
Yes.
So therefore, it is not a. His claim is not against the foreign party.
He wants to have the foreign party as well as the plaintiff in the arbitration.
No.
So that is what the application is, and he has also filed an application seeking addition of
He
parties.
is saying that foreign party and the plaintiff is the same entity, alter ego.
Yes.
Right, but not a party to the arbitration agreement. That's why.
But
All right.
GS6.
All right.
He has also filed an application for addition of parties.
Crystallize your point.
Second is that.
No, 45.
45. Yes.
Crystallize.
That one party to the alleged arbitration agreement is a foreign entity. Section 2(1)(f) of the Arbitration Act deals with international commercial arbitration.
So section 45 is the remedy.
45 is the remedy, not section 8. This is without prejudice. These are demurrable. Third is the arbitration agreement has not been produced. True copy of the arbitration agreement has not been produced. I'll also indicate one judgment, which is 2010, volume 1 SCC, page 72.
2010,
volume 1 SCC, page 72.
Page
72.
All right.
And the other point, that subject matter is not the same. That is there.
So you come tomorrow and deal with this judgment. Deal with this judgment.
I shall.
Ashun. IAGA com কত?
This is 4.
This is 4.
4 of
4 of 2024.
2024. This is an application filed under Section 8 of the Arbitration and Conciliation Act 1996 by the defendant. Mr. Rajarshi Dotto, learned counsel appearing for the applicant defendant, has concluded his submissions. He has referred to a decision of the Honorable Supreme Court in the matter of এই কক্স এন্ড কিংসটা লিখে দাও তো বাবা, যেমন আমি লিখি আর যেন ভুল না হয়, ঠিক আছে? ইন দ্য ম্যাটার অফ ইটালিক্স বোল্ড কক্স এন্ড কিংস ভার্সেস এইটা রিপোর্টেড অ্যাট এইটা, এই যে রিপোর্টেড অ্যাট এইটা, পেজ 1 লেখো। হ্যাঁ, রিপোর্টেড অ্যাট হয়, আমি অ্যাট লিখি। Paragraph. Mr. Saurajit Dasgupta, learned counsel appearing for the plaintiff, has commenced his submissions. Full stop. He shall continue tomorrow. Full stop. Paragraph. The matter shall appear under the heading for orders tomorrow. That is তারিখটা দিয়ে দাও, কত হচ্ছে? 12th কালকে, November 12, 2025. চলো লিস্ট দেখো। Can't hear you.
I am appearing on behalf of the defendant number 2.
I appear on
Your
behalf of the
Lordship.
plaintiff petitioner.
This is a case of a letter of credit, Your Lordship. The plaintiff is the exporter, Your Lordship. There are two applications. There are two suits primarily in these three items. The first two items belong to one suit. GA1 is the application of the plaintiff seeking for injunction and other orders relating to Order 38, Rule 5. They have obtained an injunction against me ad interim ex parte, Your Lordship. And the other application in this suit is my application seeking for deletion of my name from the party, since I am neither a necessary party nor a proper party. I will establish that they do not have any cause of action against
Who
me.
is the actual party, the bank?
There are more than one banks.
There are three banks that are parties to the
more
suit.
No, but letter of credit issued by the bank.
Defendant number 1.
Defendant number 1.
One
But
representation
the
bank.
actual transaction with whom?
With defendant number 1.
Number 1.
I am
Why the letter of credit was issued? For securing the price of
For
goods.
securing the price of goods that was
You
imported by
you are the purchaser.
I am the exporter.
You are the seller.
I am the seller.
Right.
I have exported around 200 metric tons of
To whom? To dependent number?
The dependent number 4.
He is not appearing.
He has not appeared.
no one else is appearing.
Despite service multiple times, Lordship will find the appearance of service on record. They have not appeared either in the application or the suit.
The defendant number 2, according to us, is the bank with which the defendant number 4 had business with. Because the letter of credit that we had received from the defendant number 1 was through the defendant number 2. We will show the lordship this message that we had received, the SWIFT message that was related to us and which carries the letter of credit from the defendant number 1, which is the issuing bank, comes from the defendant number 2, which would, in our humble submission, make him one of the confirming banks, because the other banks that are part of the plaintiff.
So none of the banks are appearing.
The defendant number 2 is one of the banks that is appearing.
You are appearing.
I am appearing for defendant number 2.
The
bank.
defendant
Is a bank.
Your lordship.
Is one of the banks.
One bank. Yes, your
The
lordship.
defendant number 1, which is the issuing bank, has not appeared. The defendant number 3, which is another bank who is a confirming bank, from which I have received certain payments.
And
has
who
not
is the
appeared.
purchaser?
The purchaser is the defendant number 4.
He is also not appearing.
All of these parties are from Bangladesh, your lordship.
Come tomorrow.
None of them are.
Let it remain as it
Your
is.
lordship.
Come tomorrow.
Only if I may say, for an order in item number 25, your lordship, we have received the affidavit in opposition from them yesterday. In item number 25, kindly grant.
Not to worry, not to worry. Come tomorrow. Let it remain in the list. Let's see.
Very
Very
well.
well. We'll file the affidavit in opposition tomorrow.
Let's see what happens. If the parties do not appear on repeated notice, I may confirm the interim order.
Your lordship, the only interim order existing is against me.
The interim order is existing against all banks. He is perhaps the only party who has bothered to appear and contest it.
Not against all banks, your lordship. I am the
Well,
only
that
scapegoat.
will be seen. That will be seen. And in this type of matter, deletion is at the interim stage.
I'll
difficult.
try to establish that, your lordship. But I want to first argue out their application in injunction. Because I'll show that I have no role.
No. You are really not opposing the injunction. You are really opposing the injunction or existence of your client in the suit.
So there are two. Yes, your lordship. Essentially in the suit, but for the
So
time
if
being,
you whether you will be allowed to be deleted at this stage or at the stage of trial, that I will have to see.
yes, your lordship, I am essentially contesting on two levels. One is that
All right,
your lordship.
all right, sir.
But
Come
and
on,
the other
next.
is whether there can
Come
be
on,
any
next. Thank you.
Yes, Lordship. I am appearing in the next matter, 27, 28, 29.
Yes, what has happened?
Lordship, in this GA3 is my, the main case has been kept on 30th of Jan.
Interim order is expiring.
No, 30th January, it has been extended. It can be kept on 30th January.
Passed over. Your other
Lordship, it may be given a date 30th January.
parties are not here. Next. Next, Rahul.
Your Honor, I am appearing for the respondent. I am led by Mr. Subhasu.
Passed over. Next. Chalo. Yes.
I am appearing on behalf of the plaintiff in item number 36, Lordship. But the
Any interim order that is expiring?
No.
Chalo.